he grabbed my hair with the other.
So the light momentarily turned red. You're in a public street, obviously with a light traffic control device. That means there was traffic that flowed 4 different ways, correct?
Correct.
And you're saying that with one hand he's operating the car, and the other hand he's able to strike, strangle, choke, grab you by the hair?
He grabbed me by the hair and pulled me over into his lap and then held me there until I pretended to go unconscious.
Hey, Julie.
I didn't actually go unconscious.
Okay, so he's operating the car, and you're saying he's choking you to the point of almost unconsciousness at this intersection?
Yes, at the stoplight. The car was stopped.
And
Hey, Natalie.
You have pictures of the marks, I would assume?
I did not take them, no.
And as an educated professional young lady, I'm assuming if the abuse was that severe, you reported it to law enforcement?
I did not.
I would assume that you contemplated seeking an order of protection where there would be specific findings and a court could make a decision on
Hey,
whether
Dobbins
you
and
were
East
abused
Elizabeth.
and set parameters of contact. Did you do that?
I did not file
Did you know what an order of protection was at that time?
No.
You did.
Not at that time. No. I'd never been in an abusive relationship before.
And you're a school teacher and you have a college degree, and you're telling this court that you didn't know what an order of protection was from somebody that had been the victim of domestic violence.
Not a domestic violence.
Well, this is 2018, so I guess the finger incident, you did consider yourself a victim of domestic violence?
I don't know.
Hey, everybody. I'm trying not to talk over them.
And the night when you indicate that Geoffrey Paschel was operating a vehicle and able to subdue, strike, and strangle you to the point that you linger into consciousness, Mr. Paschel had been drinking, correct?
Yes.
You've been drinking, correct?
Yes.
And it seems like that is a common denominator as it relates to the allegations of abuse, correct?
Sometimes.
And in addition with the bent finger, it's true that you both had been drinking, correct?
I don't recall that day.
So you do not have a clear recollection of whether you had or had not consumed alcoholic beverages when you say that incident occurred?
I don't recall that day of the bending finger. I don't remember.
All right, let's go to the next allegation that you testified about this morning on June 7th.
Accessibility short.
Took your iPhone and damaged the phone, correct?
Yes.
And based on that, let's go back to September 2018 conduct. After that alleged event, you did not terminate your relationship with Mr. Paschal, correct?
I did not.
January 7th, you said
Hey, Paul.
you grabbed your iPhone,
Hey, Sweets. Hey,
threw
Cosmic.
the phone, damaged the phone,
Hey,
correct?
Brooke.
He broke it over a table.
And at that point, once again, you did not call the police, correct?
I did not know.
You did not terminate the relationship with Mr. Paschal, correct?
I did not.
You did not go to the Knoxham Circuit Court downstairs and seek an order of protection, correct?
No, I did not.
You did not seek a warrant for vandalism and damage to your phone, correct?
Correct.
And do you recall Ms. Wilson giving a statement to the Tennessee Department of Correction, Knoxville Office of Probation?
Yes. My victim impact statement?
Yes.
Yes.
And it's true, is it not, that even though you indicated that there had been other instances of abuse, you never detailed any of the information in the report that you're testifying about here today, correct?
I'm not sure what you're asking.
Well, you never talked about bending the finger. You never talked about none of those facts appear in your victim impact statement, correct?
I'm not sure. I don't remember.
No approach. So let me ask you if you can review paragraph 17 and then also continue.
Wish it was a little bit louder.
And tell me whether that refreshes your recollection.
Hey, Maureen. That'll be off. See, we were watching this on the TV, and it's like a little bit ahead. Otherwise, I would put the TV on. But there's a lag between what the TV is showing and what Core TV is showing on YouTube.
The only thing that I mentioned here that we just talked about was
Hey, Brenda.
taking my phone and car keys, so I couldn't get away.
And you testified, Ms. Wilson, about the injuries that you say you sustained on June 19th that were subject to this trial, correct?
June 9th, yes.
And you would agree that those injuries were the objective evidence of the injuries was limited to the pump knot and the bruising and hematomas, correct?
From the pictures from the trial, is that what you're asking?
Yes.
Are those the extent of my injuries?
Yes.
The pictures from the trial were the extent of my injuries in the June 9th incident. Yes.
And Ms. Wilson, you are a intelligent young woman that obtained her college degree, correct?
Yes.
You're currently a school teacher, correct?
Yes.
And based on all of the information that you have talked about this morning, there was nothing that rose to the level of you severing your relationship with Mr. Paschall prior to the allegations that were subject to this trial, correct?
Better.
We broke up several times throughout this.
Now I can hear
2
it.
weeks, 2 months at a time, over the course of a year and a half, based on these different.
Well, my question was, you never terminated your
But we
relationship.
did eventually get back together. Yes.
And you would agree with me that there's one common denominator regarding these allegations, aside from both yourself and Mr. Paschall being present. Well, there were two common denominators. One, aside from June 19th, there were no police reports, pictures, documentation, etc. Correct?
There were pictures and he deleted them from my phone.
There's no calls to 911, correct?
There was a call to 911.
And those, you don't have copies of those calls?
I have a copy of the voicemail that they left on my phone.
Do you have any other indicia of evidence of what you're talking about today?
No.
No orders of protection, correct?
Yeah, other than the one from June 9th.
Nothing further.
Thank you, Mr. Essex. Gentlemen, you were right.
Ms. Wilson, why did you stay with Mr. Paschal for so long, even after the first incident of abuse?
He's very charming. He's very persuasive. At first, the first couple of times it happened, it was crying, begging, please take me back. I am so sorry. I don't know why I did this. I want to marry you. I want to be with you. The later incidents that happened were threats. He told me, you will have nothing by the time I'm done with you. Your family, your friends, everything will be gone. And I was so brainwashed and so broken at that point that I just completely believed him. I did not believe that I was worthy of anything else other than what he was doing to me.
Did you love him?
Yeah, I did.
Nothing further, Judge.
Your cross. Move, Your Honor. Ma'am, thank you.
Thank you.
Sit down.
Well, I see that Byra's there. Mary,
Yes, I did.
one of his sons,
No, thank you.
Ashley, on the front row there. This is a different judge than last time, right? It's the same judge?
Tell the truth, the whole truth, and nothing but the truth, so help you God.
Can you state your name for the court reporter?
Allison Moon.
Ms. Moon, do you know Geoffrey Paschel?
Yes, I do.
And how do you know him?
I know him because I was previously married to him.
When were the two of you married? What were the years?
We were married from, well, I met Mr. Paschal in 2006, late 2006, and shortly after that, we got married, and we were married until mid-2013, roughly.
6 years you were married. Do the two of you have any children together?
Yes.
And how many?
We had one.
And how old is it boy, girl?
It's a boy. His name is Crusoe, and he is 10.
And you know why you've been called to court today.
Absolutely.
And you know that Mr. Paschal has been convicted of several things related to Ms. Wilson, correct?
Yes.
I want to talk to you specifically about some things that happened.
I thought that
during
was
your
Mary at
marriage to
first,
Mr.
Brooke.
Paschal. At any point during your marriage, was there physical abuse?
Yes, there was.
And if you could, to the extent that you can just kind of recall it off the top of your head there, can you just tell us about specific instances that you remember?
Sure. Early into our marriage, a couple months in, there was definitely verbal and emotional abuse. He would
Your Honor, I would object. The enhancement factors talks about prior criminal offenses or criminal behavior. Verbal domestic arguments would not rise to the level of satisfying the enhancement prong of Tennessee law. It would not be admissible or appropriate, so we would object, move to strike, and ask that it be excluded further from this hearing.
General.
Judge, I will just ask her about the physical abuse. However, if there were instances of verbal abuse where you felt like you were being...
Talk to the witness, she can ask the question and allow me to object.
Okay, here's how I'm going to rule. I'm going to sustain
the objection in part with a clarification. We don't need to hear about verbal altercations. The general is aware of our state's
assault statute
and
how certain verbal behavior could rise to the level of criminal activity. You guys are well aware of that. I will allow that type of evidence, but otherwise, the general district may focus on questioning regarding specific instances of alleged criminal conduct.
Yes, Judge. And so, with that, can you tell us about any physical abuse or were you ever put in fear by any verbal abuse?
Absolutely. There were many threats made to me and to my family. He was violent to me on numerous occasions.
I'm going to stop you for just a second. When you say threats, what kind of threats?
To kill me, to harm my family, and one of the last physical altercations that we had was I was arriving home after spending time with my cousin, with my son at the time, and he didn't believe that I was where I said I was, and showed up at my home, grabbed me and threw me into the bathroom, closed the door, told me not to leave. There would be consequences. He took Crusoe and put him in the car and left. He had taken my keys along with that. After sitting there for a little while, I opened the door and quietly came out. He wasn't in my house anymore. Happened to find, I found my phone and contacted him to make sure my son was okay. That was my primary concern.
Why wasn't she called as a witness before?
Shortly after, he came back to my house, and nowhere in sight was my son. But he immediately attacked me and grabbed me and shoved me into the wall, threw me on the ground.
Oh, she was? I'm sorry. I might have missed that part.
When I finally broke free, he went and swung at me, and I moved so he could hit the top of my head versus my face. And after that struggle went on for a good 20 minutes.
I just remember seeing her when, back in October.
For him to stop.
But we did catch it late. So was she there or was she not
I
there?
asked where Crusoe was. He went and got him out of the car.
I don't think she was
He in the
there.
car by himself the whole time.
Watched it the whole day.
How old was he at this point?
He was a year and a half. And he hung around.
She wasn't there. Okay.
I mentioned that Crusoe had to be put down for a nap, so he hung around.
You would think that her testimony would be pretty
After
damning.
that,
I would think so.
he pulled me into our bedroom and started taking off my clothes. Was wanting me to have sex with him. I was scared that if I resisted, that he was going to become violent again. So I just let it happen.
Objection, that's not criminal behavior.
I'll be the one who determines what criminal behavior is. I think that's relevant. She's describing these attacks. We can't pigeonhole her testimony into the very small confines in which you're wanting to do this. If we were trying this case at trial, for instance, this would all be relevant to show the circumstances surrounding this alleged conduct. So the objection has been noted. We need to hear what this witness has to say, General.
Were you done with that, sir?
No, so when he was forcing me to have sex with him, I was in pain. My back was hurting. It was just when he was grabbing me in the course of it,
I think so too, Brooke.
it was very, very painful. And then it was over and he left. And then shortly after that, I had a friend come over and help me pack up my things in one day. And then I took my son and myself and we moved to Florida to live with my parents. And that was...
There's a guy sitting behind
the
Varya.
last...
Does anybody know who that is? Or next to her? He keeps like holding her
I want
hand.
to talk to you. You were in the courtroom when we were talking about the email.
Or her
that you
arms,
sent
his
to me
arms around her.
yesterday. I want to talk to you about some specific incidents that you listed in here.
Objectively, you should ask her, I think she just testified that was the end of the abuse. so now she reads from the email one that's leading, and I think it would be appropriate to use that. I mean, she's seeking to, I guess, introduce a prior consistent statement.
As I took
Oh, they show the audience on the TV. I have it on my computer, and I have it looking at the TV too.
So if what I think is happening is that the prosecutor is referring to incidents that occurred before that. So, of course, the state can't lead. I don't think she was leading. I think she was just directing her to other incidents. So I'll note the objection, Joan, you may ask.
Can you tell us about the first time that there was physical abuse?
Yes, 4 months after we were married, we were having a conversation, and it was not long into our marriage, I began to question his fidelity and whether he was maintaining loyalty and being honest with me about things. And so when I brought it to his attention, he would often get defensive and start to make me think that what I was saying was wrong, or that I was crazy for thinking so. And the first time I had said something, and it just immediately snapped, like no warning. He jumped on me and held me to the ground, but had his hand over my mouth, just squeezing it, like, hey, stop talking, basically. And after that first time, he was extremely apologetic and promised it would never happen again, and wanted this marriage to work out. And I believed him.
That guy.
After that, though, there were many instances of increasingly more violent things that he did to me, such as strangling me, holding me on the ground and strangling me, and dragging me by my hair, backhanding me in the face. He's elbowed me in the back, and each time he would be threatening me and I didn't believe I could do anything about it.
Because oftentimes my phone would have ended up broken in the course of our arguments. My keys would go missing, or he would have him. And then he's often disabled my car before, so I couldn't leave even if I had the means to leave or get help. Where he lives in a rural area, it would take me a long time
To get out of the house and run to a neighbor, so I felt very isolated. Slowly, from the beginning of our relationship, I became estranged from friends, and it became more and more of a fight to see my family. Financially, I didn't have the means to go and get away from him. He made me dependent on him. But yeah, it went on for a long time.
Did you ever call the police during any of these instances?
I did one time.
Can you tell us about that?
So there was a time in our marriage where we were separated. I lived in Florida to go and get my master's.
It's pretty rural, Deborah. We've been
Showed up
there.
unannounced one night,
It's
and this was during a period where things
it's very woodsy.
weren't going well in our
So I have
relationship.
to agree that
Since
it is
was
very,
a roller
very
coaster throughout our whole marriage. He showed
secluded.
up unannounced and walked in through my back door at my parents' house, and I was startled because I wasn't expecting him. So the first thing I did was
It's not
my
rural
phone,
because
the
like you
typical
just like
pattern is you take my phone.
it's
so I
like
wouldn't
10
have
minutes to
means
the main road,
contact
and then you see
anybody.
a lot of stuff. But like
And
to get to his
when
house,
I came
you
back,
have to
I
take
found
this
him in
one
the
street, and
kitchen,
it's
and
twisty and turny, and
he
it
started.
goes down a lot.
He got close to me and was talking to me and trying to.
I wouldn't say he lives in
smooth
like the
things,
middle of
would
nowhere,
talk
but
me and
where
then
his
ask
house
me-
is situated,
Before I
it's
knew it,
pretty
I had been
for that little area. It's
Like,
secluded.
backed into my bedroom.
You have to go 15 minutes down the road, then you
And
have
I remember
stores and
him
stuff like
forcing me
that.
onto my
So
bed, and he started touching my private areas and telling me we're gonna have sex, and I didn't want it. I was telling him no, and I was able to wiggle free. I ran out of the back of my house, knocked on my neighbor's door, rang the doorbell several times, and he had come out of my house and left, and I went inside and locked all the doors and called 911.
So you actually did make a police report that time?
Absolutely, yes.
And you described all of these events?
I did make a police report, but I didn't follow through with charges because I was so afraid of what he would do if he'd come back and do worse, or he was unpredictable. In 2010, yes.
Do you know where Mr. Paschal resides at that time?
Tennessee.
And
But I don't know if that's where if he was living at that house when he was married to her. I'm not sure if it's the same
so that this sort of abuse was kind of
location.
happening throughout your entire 6-year marriage.
That I'm not
Yeah,
sure of.
came in
They might have lived
cycles.
somewhere else together. I don't know.
Okay,
I don't know how long he's at that house.
Things would seem normal, and then with little notice, he would snap, be in like a fit of rage. We would have, there were always arguments about, you know, if he was telling me the truth. I was always very weary, but it was, but
No, this is not.
everything
This is
would
a
always
different
be
wife. She's
unpredictable
got
to
the
what would
10-year-old.
happen next, and I would leave. I've left numerous times, but he had an extra key to my car and would come and take my personal belongings out or disable it so I couldn't go anywhere. So unless I relented to what his demands were or what he wanted, which was usually for me to come back and promising me things are going to be okay. And then a few months later, the cycle would begin again, and there would be an argument that would lead to him being violent, and I'd be right back wishing I had left or could leave, but always felt like I couldn't.
Brooke, who is that? How do I not know this person?
Judge, I'll pass the words.
Good afternoon, Ms. Moon. My name is Gregory Isaacs. I represent Geoffrey Paschel. You and Ms. Wilson are friends, correct?
Yes,
You talk almost on a daily basis, correct?
more of like a weekly basis.
And in fact, you have an ongoing
Okay.
domestic civil case against Mr. Paschel, correct?
I do not have a I have a domestic case. Yes, it's child custody related.
You hesitated. There is a pending civil litigation where you are the petitioner, he is the respondent,
It's
correct?
actually been resolved. That's my understanding. Now, there might be a new motion for something else, but
And in fact, Ms. Wilson, in that case, testified on your behalf, correct?
Jeffrey's
Yes.
attorney does not come off likable at
And
all,
you and Ms. Wilson have talked
especially
about
the way
your
he
testimony,
talks to the women.
here this morning, correct?
no, not my testimony this morning.
Well, you've talked about your testimony, correct?
We've shared experiences together, but that didn't begin until after 2019.
Okay.
And
If you could please answer my question.
Judge, I would ask Mr. Isaacs to
I agree, Brooke.
stop kind of being a little hostile towards this witness. She is
See?
not answering your question.
Even the DA just said it. You're being hostile.
We're
Mm-mm-mm.
fine here. Just let Ms. Moon give her answer and ask your next question.
Well,
Agreed.
Ms. Moon, I apologize if my demeanor is hostile, but Your Honor, you're a hostile witness, you're adverse to Ms. Paschal, and you never talked about in direct any of this information regarding your relationship
The
with
records, let me clarify something here. Ms. Moon, as far as I can see, is not being a hostile witness. That's a legal term for her.
It is legal.
She is answering both parties' questions, I feel, to the best of her abilities. The court is not finding her to be a hostile witness. I just want that to be clear in the record. Go ahead, Mr. Isaacs.
When did you last speak with Ms. Wilson about your testimony here this afternoon?
the last time we spoke about it had been within the coming weeks of being here.
Brooke.
And in fact, you wanted to testify so much that you actually have come here from out of state, correct?
Yes,
And Ms. Wilson asked you to come here, correct?
there was no question of her asking me to come here. I was going to be here to support her.
Well, let me
So does
ask
she
you
live in
this.
Canada?
Can you relate to me the substance of your conversation with Ms. Wilson about what your testimony was going to be this morning?
We discussed that we were going to be sharing our experiences that we endured while with Mr. Paschal. That was
Florida.
it.
Okay.
No,
Canada or
not in
Florida?
detail, because there was no need to.
I'm
at
still
that
trying to
point.
figure out why she wasn't there.
Why would you feel the need to talk to Ms. Wilson about testifying on behalf of the
Court.
state truthfully regarding these allegations that span over 15 years? I mean, they're 15 years
AD.
ago with the 6 years you were married.
Because we were friendly and we're friends and we've endured similar experiences, and it's through a means of support to one another to know that she's not alone.
And would you agree with me that both you and, well, let's talk about Ms. Wilson, that you don't like Mr. Paschal, your ex-husband, the father of your 10-year-old Caruso, correct?
I don't have any feeling
so now.
different to him. He means nothing to me either way. I don't spend a lot of time thinking about him.
So if I recalled Ms. Wilson to the stand, she would say that you've never had disparaging conversations about Mr. Paschal.
Wait, Geoffrey was
We
married
both
4
agreed
times?
that he was a very harmful man.
So my point is, you both have a bias against Mr. Paschal, correct?
Yes, we definitely do. Believe our experiences warrant it.
And you have not only a bias, but a very strong bias, correct, Ms. Moon?
I endured several
This
instances
attorney
of
is not
violence
doing it
with
good.
this man. Of course, I have feelings of dislike toward him, but I don't dwell on it, or most of the time our conversations
Me neither, Wicked.
over the couple of years we've talked to each other have been about our lives.
And let's talk about these allegations. Now, you, are you employed?
Yes,
As, what's your position? Are you currently
I'm a
employed?
teacher. I'm a 4th grade teacher.
Okay, you're a teacher. Obviously, you have a college degree, correct?
Yes.
And you know that there are resources to help people if they are, in fact, involved in an issue of domestic violence, correct?
Absolutely.
If what his
And
ex
with many
if what his
of these
ex-wife is saying is true, of course she'd be
allegations
biased
you
towards him.
reside in Florida, and Mr.
What is she supposed to write him a letter of recommendation?
For
That makes no
for
sense.
half of our relationship, we were, well, for 1 year of our relationship, we lived separately, or year to 2 years. The first 3 years of our marriage, we were living together. And many of the altercations happened during those 3 years. They got increasingly violent over those 3 years. When I came back and after I had my son, that's when I experienced the most violence from him.
All right, let's get this straight. One, for the 3-year period, no calls to 911, correct?
No calls to 911.
So we can't tell if you ever made a complaint of domestic abuse or if there was an escalation of domestic abuse, correct? As it relates to 911 calls.
Correct?
There were no criminal warrants taken out regarding this conduct, which appears to constitute assault, battery, strangulation, false imprisonment. No warrants. Never sought to have Mr. Paschal arrested, correct?
No, I was in complete fear of doing so with the threats he had been making to me leading up to these physical violent altercations.
Never once sought an order of protection.
For what? He could still come after me. He had a copy of my key. So no, I didn't believe I had the means to do so and be safe from this individual.
All right, so for the first 3 years, you say there was abuse, and instead of running, instead of calling 911,
Agreed, Geneva.
protection, you had a child, correct?
I didn't have the means to call 911. I didn't have the means to leave the house. He had my keys. He would destroy my belongings.
Or if you can answer my
So no, I didn't.
Okay.
Did we have a child to make our relationship better? I mean, there's no telling. Did I think it would help? Perhaps, but honestly, because he would
describe to me that would make a difference.
Well, my question to you is, after 3 years of this alleged abuse, instead of asking for help, you decide to start a family with Geoffrey Paschel, correct?
Yes.
And you started a family with Geoffrey Paschel because you think, or you thought, he would be an appropriate father.
I was
Correct?
hoping he would be an appropriate father.
So, really, Ms. Moon, if you thought he just continually abused, slapped, strangled, drug you around, that's not someone you would have planned a family and have children with, if that's true. Correct?
After being several years outside of our marriage, no. Back then, my head was not clear. I was filled with the threats and the fear that he built, the criticisms, the constant harassment. He did nothing to make me believe that otherwise.
And this abuse and this brainwashing was so severe that you never called 911, you never called police, and you never got an order of protection, but yet you started a family with Geoffrey.
Yes, I did, though I didn't have the means often to get the help I needed when I needed it. Because after
Agreed, Julie.
after the storm, it was calm, and I thought I could believe that things would improve, and they never did, and it was a vicious cycle of that.
Okay. Now, you were married to Mr. Paschel from 2006 to 2013.
Yes.
And there has been a variety of very acrimonious civil lawsuits, pleadings, motions, contempts, etc. Correct? Filed in court.
Between who?
Between you and Mr. Paschel.
Yes, regarding child custody.
And it was and is a hotly contested issue in circuit court, correct?
It was concerning based on his continued criminal behavior and repeated actions that kept happening with other women. So yes.
Well, let's talk about what happens today. The longer the sentence Geoffrey gets, that helps you with your custody battle with 10-year-old Caruso.
Oh, wow.
Caruso already did not have a relationship with his father for the last 5 years, so it wouldn't make a difference to me today.
Well, you filed a petition to terminate Geoffrey's parental rights, correct?
Correct.
So you have other motivation than the abuse that you never told anybody about to testify adversely to Geoff Paschel today, correct?
I have motivations to do what I think is right by myself, by my family, by the women that he will continue to be a predator to.
The women. So you represent the women, that's why you're here?
No, I'm saying theoretically, I'm not one. Clearly, I'm two, one of two, and then there's other women that he's been involved with that have endured violence by him.
How do you know that?
Because I've seen court documents that state that from other people he's married to.
Mm-hmm. And you all talk, correct?
Incorrect. I've
Talking
never had a
about
conversation with his most recent wife.
Well, let's talk about this period that you were married from 2006 to 2013. Okay. You have talked about issues of abuse that happened in Tennessee and then issues of abuse that happened in Florida, correct?
Yes.
Can you name a single date and time that one of these alleged events occurred other than the nebulous 6-year period? A single date or time if these are indelibly etched in your memory that they occurred.
I mean, I can remember months. Dates are a little bit more challenging to pull, but I know that, when he showed up at my house, I believe it was August 28th or 29th of 2010. I know the last violent act that I recounted was August 2013. It was within the first weeks of August. But remembering, I don't know how remembering a specific date is important. It's been a long time. And clearly these memories stick with me, but I don't remember the specific dates of many of the encounters.
Well, let me ask you this. If this abuse was so severe and so pervasive, you can't even tell the court the day of the week or the date that it happened?
Again, with time, it leads my memory to be fuzzy on specific dates and times. I often, in the
I mean,
midst
that was
of
15 years ago. You're supposed to remember it happened on a Tuesday or a Wednesday.
use,
I mean,
I'm not going to refer to a clock so I can remember in the future to tell the court what time something occurred. It just doesn't.
No medical records provided to the prosecution of abuse?
No.
Absolutely nothing to corroborate your story, correct?
Correct.
It's you and Ms. Wilson talking on the phone week after week, and you representing all those women to lock Geoffrey up in criminal court, correct?
I have said in court documents prior to meeting Kristen my experiences with Mr. Paschall. So this is not new, as in me talking to her and coming up with the story.
Let me ask you this. The state is
he's trying to say that she's in cahoots with
Yes,
Kristen
correct?
Yes.
to get
The hearing was today, correct?
Yes.
And
Custody.
So you chose to give them all this information of abuse, knowing that my investigators, my office couldn't investigate, correct?
Judge, I can interject here. I specifically asked her to send me this yesterday, and that's what she did.
Then I will withdraw the question. I have nothing further.
Thank God.
Very grateful, Judge. How did you and Ms. Wilson begin communicating with one another?
I received her police report in the mail from my lawyer
Okay,
in
and
August of 2019.
did it contain her phone number?
Yes.
Did you reach out to her first?
Yes.
And was this before or after the June 9th of 2019 incident?
After.
And prior to coming into court today, did you and Ms. Wilson get together and say that you're going to testify one way and she's going to testify one way? Did that ever happen?
Definitely not in that way. No.
And like you stated, the allegations that you're talking about, this is not the first time that you've been in court and stated these allegations.
Correct.
You pled them actually in many of your custody documents.
Yes.
Okay. Custody documents that Mr. Paschall received.
Yes.
Nothing further.
And in fact, Ms. Moon, you really were not as scared and frightened of Geoffrey as you're saying today, correct?
Absolutely.
Well, you were so not frightened and so comfortable that in 2013, you agreed to give him 50-50 custody with your son Caruso.
Yes, I agreed to 50-50 custody up until the age of pre-K, where he would begin school. So in my mind, if I could come to an agreement with Mr. Paschall without there being threats and further violence, then I was going to try to be amicable and do that.
So you have somebody that you describe and you're still describing as violent, unpredictable, and whatever, and you agreed to let him have Caruso 50% of the time, unsupervised, no parameters, correct?
Correct, and I was doing that in hopes that he wouldn't do something to hurt my child or for my child not to witness further domestic violence with other women he brought into the home. And
Well, let's not talk about other women. We've talked about that before, but isn't it true that you or any mother, if all of this violence is true, would never have
Object.
Well,
Well, speculate what other mothers would do.
What?
Just saying, you can rephrase the question.
I don't think I have anything else to ask this witness. Thank you, Ms. Moon. Yeah. Ms. Moon, thank you for being here today.
Ms. Moon, subject to recall. You can remain in the courtroom if you'd like, Ms. Moon. Yes.
So is he even getting sentenced today?
Before the state calls the next witness, we do need to take about a 5-minute recess. If you anticipate being a witness in this case, as we've discussed, do not discuss your anticipated testimony with anybody until you're called into the courtroom and sworn. We'll be in a 5-minute recess.
So he's still married to his third wife? So Geoffrey's saying that all his exes conspired together. And I guess that's why his attorney is going through this line of questioning. So what's the minimum? The minimum is 12 years, right? That he's looking at? Oof. It's a long time. And I think he's going to get more than that. And to think, didn't he say that either they gave him a deal to do no jail time and just like probation or something like that originally?
It was a plea, like his first plea, but he said I didn't do it, and I don't want it on my record, so I'm going to fight it.
Well, it wasn't like his record was, clean as a whistle.
I know, but still, you don't need something else added on to it. If you didn't do something, then obviously you want to prove your case. You know what I mean? And it kind of pretty much fucked him.
Wait, Paul, what did they ask for again today?
Okay, the guy is sitting behind her. Now
Yeah, he's a blogger, is what I'm being told.
He's behind her. Yeah, he was down here at the end next to that girl, but yeah, he moved behind her. I see it in the other shot. I thought he was holding her.
Well, doesn't he have to be sentenced before they can appeal it? I don't know. Oh, I got you. I mean, he already went to, jail for, like, the drugs and all that stuff. It wasn't like he had a squeaky clean record to begin with. No, I mean, Geoffrey was, you know, he said it that he's going to win, and that's why he didn't want to take the deal, because he was innocent. I think the plea deal was like no jail time and probation or something like that. I could be wrong. Well, you got Varya there, you got Mary there, and you got his son there, and Ashley's there. I would think that any of them could be called, but I don't know if they're gonna do that. Well, he had four kids, right? One, the baby that had passed away when he was with Kristen, and three other boys, right? One boy is Miss Moon's son. I'm guessing he's not there. But what they were saying about the gate earlier, he does have like an electric gate. So to get, and it swings wide open. So you need to be like buzzed in or buzzed out to get out. What a mess. It's just crazy to me to think like they offered him a plea of no jail time and probation to go to like 20 years. That is an insane jump. I mean, some murderers don't even get that much time. This is some 5 minutes, huh? Hey, Shelley. And his attorney is not doing him any favors. I know, Denise. I didn't think this was going to be a thing today. I thought they were going to, like, they was going to come in and then they would do sentencing. It'd be like over in 20 minutes. I never thought this was going to be like more trial and testimony. I mean, I just can't believe she wasn't there in front of the jury, what the ex-wife said. you'd think you'd want a jury to hear it, but I don't know. People said maybe it was because of Rona or whatever that she couldn't make it. So she lives in Florida. She's not from Canada. Because if she lived in Canada, then I could see like, oh, well, maybe she couldn't make it. The Geno stuff I'll get to. I'm still putting it together. I mean, this isn't even in front of a jury. This is just for the judge, really. That's got to be rough for the son to be there and listen to all this. God. To hear all this stuff about your dad. That's tough. John Nelson. I think they adjusted the charges after he was. That might have been that would probably make sense.
Is he going to be sentenced? Or
Everyone says he's going to be sentenced today. It's enhanced sentencing.
Well, like you said, yeah, there's no jury, so this is all for the judge to for him to make his final.
They're going to throw the book at him.
No, don't say that.
No, they
Fingers crossed. Keep faith. Keep hope. Can't say that.
Well, the ex-wife
They don't.
said stuff was pretty damning.
But also, she also kind of made herself look bad too by not filing reports. And stuff. She also,
Here we go. We're back. The guy with the beard is his son? Oh. I see at the end. That's his son.
that's the one by
Yeah.
the woman, the 10-year-old. Is that him?
No, that's not the 10-year-old. That's a different son. The guy in the purple shirt, Julie, at the end, all the way to the left, that's his son too, with that big beard. I see Ash. There's a guy, then I guess his wife or something, then Ashley. Where's Mary? Oh, there's Mary.
Yes. Yeah, I think I can do that. Okay. Well, the thing here, I don't see it. So.
See, it's funny. They mute this here on Court TV, like when they're doing the sidebars, but you could hear it. You could hear the sidebar on the TV. I don't know why they mute it when they stream it through YouTube. It's weird. Why is it still muted? What is happening? I could put the volume up on my TV.
It's not up to where you guys are though.
I know, but I don't know if they realize that it's muted on their end. Oh, there we go. Or not.
This with counsel, state's attorney is here with us. I was informed by my court officer during the break that we were having an issue with one or more people in the gallery. I'm not exactly sure. Having verbal, audible responses to some of the testimony that was being provided. I want to make very clear that we have to maintain decorum and order within the courtroom, and part of that is that there can be absolutely no responses from the gallery, either verbal or nonverbal, as to any of the testimony that has been provided. I understand my court officer during the break provided the appropriate admonishment to that effect, and I also understand that Mr. Isaacs spoke to some of the people on his side of the aisle to that same effect, and I do appreciate you for doing that, Mr. Isaacs. General, you ready to proceed with your next witness? All right.
Not line witnesses at this point. We do have a video.
Oh, boy.
Of the defendants that we would seek to introduce. That's we haven't introduced anything yet. We had one for ID, but
Yes, this will be number 2. Is there any objection? No. Okay, so we received is number 2.
it's about a 15-minute long video. The defendant has a jail visit with his mother, I believe. It's the relevant portion that I was wanting to play for the court. Begins at 7 minutes and 45 seconds.
Okay, would you like to publish that at this time?
I would have.
You said 7 minutes and how much?
45.
Is this his mother going to go visit him in jail now?
What are you reading?
Can we go to your house and make sure everything's okay? Josh,
For the record, I've started the video at 7 minutes and 30 seconds.
Josh and Ashley are there, so they can relate, right?
Go talk to who? I can barely make it out. He's asking her to go talk to somebody with the kids.
Okay.
They bumped Mary from. Wow. Mary was his other girlfriend on the show that was at the end. Remember, if you remember watching before, and Vara comes to the house to surprise Geoffrey, and Mary's there.
Okay, for the record, I'm stopping the video at 10 minutes and 41 seconds. General, I'm assuming the date on this is, it was recorded on January the 28th of this year.
It was not, Judge. This was actually October the 17th.
Okay. All right.
Yes, Vara and Mary are friends, I believe.
The next thing is I've got certified copies of convictions from Warren County, as well as certified copies of convictions from the District Court in the Eastern District of Texas. So I would ask those to be the next exhibits. The Texas ones are two separate ones, so we want to make those separate.
Sure. Let's mark them all separately. Any objection to those, Mr. Rice?
The only, obviously, I'll take the state's representation that they are certified. Pursuant to TCA 106A1B5, there has to make it needs to be a finding beyond a reasonable doubt that the out-of-state conviction, if it's used to determine a sentencing range, must be compared to Tennessee law as it existed at the time. I understand from talking to Ms. Good, she is going to establish that prong, but that would be our only objection as to the foundation on federal conviction, not state.
Okay, sure. So it sounds like there's no objection as to the admissibility, but you guys may argue over the effect of the.
Well, it's not admissible unless you can show what the sentencing range is that existed at the time beyond a reasonable doubt. And Tennessee law,
I have no idea, Julie. I see him.
Well,
it's
admissible, sure. Right. If for no other reason, it would be admissible as prior criminal conduct. But we can argue as to the import that it has on what range you sentenced at today, for sure.
In response to the question, we don't object to admissibility. We like to hear on the issue of whether it should be considered enhanced factor for range.
Of course, yes, sir.
Next thing would be the pre-sentence investigation report and the addendum to pre-sentence investigation report. Do we want those in its collective or?
Any objection to that?
I have no idea, Brooke.
Collective's fine. I think they're really the same document.
So I'd also like to give her a copy of the Ms. Wilson's medical records, along with the affidavit of the custodian of records.
we would make the same objection regarding medical records that we did at trial. And then the 90-day notice of provision, and we still not received memorandum of any of the statutory prerequisites to have medical records.
Judge, I'm not sure what this 90-day, I'm not sure that the rule actually calls for 90 days.
So we're talking about authentication through the affidavit of the custodian of records.
Yes.
And I know there's a notice provision. I don't know. Well, for one, has there been notice provided that you intended to introduce these through an affidavit?
So I provided them with these records almost 2 years ago. At trial, the court did exclude the medical records because I had not filed written notice. However, and if the court would like to see the case, now I can't remember it, of course, because we're talking about it, there actually is case law stating that if the records are provided to defense counsel in discovery, then that in and of itself puts them on notice that this evidence could be, sought to be introduced. And that written notice actually is not required by the rule. It's right. Give me a moment. I'm happy to go find it. But again, they are on notice that we could seek to introduce these, even from the trial.
Well, we are noticing the opportunity to seek to introduce, so we would do our same objection to that trial.
It does say that written notice is required. However, the case that I'm specifically referring to, and I'm happy to go and pull it if need be, states that once the state actually puts it gives it to defense counsel and puts it in their discovery response or something like that, it then puts them on notice that it could be sought to be introduced.
Okay, well, I'm in a position where I don't have that case in front of me. All I have is the rule, and the rule is pretty clear that a party intending to offer a record of evidence under this paragraph, referring to business records, basically,
I agree, Holistic.
must provide written notice of that intention to all adverse parties and must make the record and declaration available for inspection sufficiently in advance of their offer. In evidence to provide an adverse party with a fair opportunity to challenge them. So I'm kind of at, here's what the rule's telling me. I don't have any authority telling me otherwise that I'm aware of. So I will sustain the objection at this point. That'll be for the rule. All right. Any other proof, John?
And Judge, I don't know. I do have a copy of the statute as it existed in 2000 related to drug offenses in Tennessee that Mr. Isaacs was referencing. I don't know if we want to introduce that as an exhibit or just tied.
Well, I think he did like 5 years for that charge.
Now, is that a federal statute or Tennessee
This is
statute?
the Tennessee statute. So and I guess we can talk about this a little bit. So the conviction, the federal conviction is for possession of cocaine with the intent to resell. Well, he's got an attempted and there's two. And so I've got the Tennessee statute as it existed in 2000 at the time of those convictions related to the possession with the intent to sell controlled substance.
Yeah, Mr. Isaacs, you might have to take a copy of that.
Yeah.
Thank you.
So I think all of the
Agreed.
proof at this time, just ask for argument.
Okay, state objective to proof of sentencing, will there be proof of defense?
Your Honor, we have a number of arguments to make regarding our sentencing memorandum. We have no proof at this time.
Okay, very well. Let's move on to argument. And I guess if both parties could begin with their arguments as to the appropriate range of sentencing.
State's contention that Mr. Paschal is a range 2 multiple offender based on numerous convictions that are now entered into the record, the first of which being a conviction, actually 2 convictions out of Blount County, but the state does concede that for purposes of enhancing the range, because the date of offenses were the same, I think that they would actually only count as 1 conviction. But those were for B felony, the sale of, I believe, if I may draw that. Blount County convictions were 2 B felony convictions in 1999. One of which being the possession of a Schedule 6. I'm sorry, that was a misdemeanor conviction. I apologize. He had possession of Schedule 2 with intent to resell, Class B felony, and possession of Schedule 1, Class B felony. So those were in cases out of Texas. The first one was possession with intent to distribute cocaine and marijuana. And the second one was attempted possession with intent to distribute cocaine. So, for purposes of the statute as existed in 2000 when he was convicted, the statute states that, again, the issue that we ran into here was the judgments in the federal cases don't actually list a specific drug quantity. And so we have been going round and round with the district court in Texas. The only way that we could get something that specifically stated the drug quantity was in their version of a PSI, which is sealed. And I even had an AUSA out there attempt to file a motion to get it unsealed. That was not fruitful. So while the state cannot say a specific quantity as it relates to these convictions, when we look at the statute as it existed in 2000, and it's really the same language even today, basically. At a minimum, the sale of any amount of Schedule 2 cocaine would qualify as a Class C felony. And so the state contends that we have the Class B felonies in Blount County, as well as the federal convictions that at a minimum would qualify as a Class C felony under Tennessee law. And so we would ask the court to find that he is in fact a range 2 multiple offender based on this.
May it please the court, this is a quintessential example of why Tennessee courts and statutory law require a finding beyond reasonable doubt. TCA 4035-106A1B5 provides when classifying prior out-of-state convictions to determine sentencing range, elements of out-of-state offensives must be compared to Tennessee law as it existed at the time of the prior convictions. Not as the law currently exists, citing in the commentary State versus Brooks, 968 Southwest 2nd, 312, 1997. What the issue is before the court, one, in drawing on our experience, and I would ask the court to draw judicial knowledge in terms of being a federal practitioner and dealing with pre-sentence reports, they do not contain the elements of the crime. The judgment for federal judgments, as you can see here, are very formalistic and do not contain the elements of the crime. One thing that's very important when you look at the issue of separate sovereigns, you have the federal forum, you have the state forum. At the heart of the charges is quantities. Federal drug cases begin and are driven by drug quantities. That's why the state sought an AUSA who tried to unseal some of the information. That AUSA reached out to my office. We did not agree to unseal pre-sentence report. So we would respectfully submit that without information regarding the elements of the federal offense compared
His
to
attorney is the type of guy that
elements
loves
of
to
the
hear himself speak.
current Tennessee offense, as it existed at the time, it would not be an appropriate enhancement factor under 4035, 106A, 1B5, and also under State v. Brooks. But quantities are very important. Quantities under federal law have changed regarding
Like one of those old-time litigators, like, ladies and gentlemen of the Jura,
whatever. So the fact that the state
we are here in this grossly, you know, like that type of guy.
successful shows that they know they need more. And again, if he springs one, that's still a very significant range for what Mr. Paschal was convicted of. But we would respectfully submit that unless the state complies with the letter,
Like, I'm surprised he doesn't have a top hat on.
letter of this, and that's why when we have issues with federal cases, state cases, in terms of trying to keep people written, trying to do this, it's a very cumbersome process. And if at the last minute you say, hey, I need this unsealed by federal court, that's not the way it works. I mean, it would probably have had to have been an appearance from someone here or someone appearing pro hoc vice on behalf of the Knox County Attorney General's office in that federal forum, seeking to unseal the records and getting those certified. But that state has not met the requirement as articulated in State versus Brooks. We think that should not be considered as an applicable enhancement factor, and that Mr. Paschal should be range 1.
Can I please withdraw those judgments?
Just a second.
And I guess also the Blunt County judgment as well. Thank you.
Hey, Robin, welcome to the shit show. You gotta call the shop.
What?
You gotta call the shop and see about the
I'm
phone.
not ready.
What?
I'm not ready.
We'll call us to make sure. Oh.
This is a somewhat different issue, but I do want to ask. I'll ask Mr. Isaac first, and then I'll ask General Good. I'm not seeing anywhere in here where it says the date of the offense. Have you found that in here? Do you know that it's? I'm talking about the federal judgments. I know that's listed in the state judgments. I see. Okay, very well.
I'm already exhausted, Julie.
Well, I'm not sure. I'm not necessarily sure that it is. When you say you have the documents, you mean the complaint?
I have a, yes, I have, the indictment. I pulled them off the case. No, that's not what they're on, but
They're inadmissible. Okay, I just had that question.
Cody, ask if we don't make it there today, if we can pick it up tomorrow. If it's okay, if we don't make it there in time. I don't know how long this is gonna run.
And Judge, I would note, as far as the, because I kind of thought that these might relate to Blount County cases as well initially. If you will look on the Blount County.
And I feel like we're gonna be here
Offense there, I
all
believe it's
day.
1997.
We do have the date that the offense concluded
On the front of the federal judgment. The federal judgment has an offense date conclusion of 2000, if that clarifies it all.
Oh, I see that on the face of it, yes.
Yes.
I don't know how I missed that. That does answer my question.
No worries.
Any further argument as to this issue, General?
No, Your Honor, the last thing we would say is just that we do not believe that a specific quantity is necessary. I did try and get that just for, to see if we could make it a little bit easier. But nonetheless, like the statute plainly says in 2000 and even today, the possession with the intent to resell cocaine in any amount is at a minimum a Class C felony. And so we would ask the court to find that he is range 2.
And you're saying that the attempt would be a D,
I think the attempt would be a D.
which
Yes.
should go up to classifications to catch the B aggravated kidnapping.
Yes.
Okay. I gave her the last word, Mr. Isaac, but it looks like you have something.
You did. I tried to sneak out.
This is an important issue, so if you have argument on it, I'll.
And I think the court for your careful consideration, but just simply, that's not enough to make the determination what we have for us here in a federal case, and that's why they tried to unseal it. The federal judge said no. And again, the standard's beyond a reasonable doubt. That's why we certify things here. Tennessee, that's kind of archaic, kind of like the old wax stamp and whatever. But there's not enough to make the required finding when you compare the elements and the ranges, because we're guessing at things as we're talking. And I don't mean guessing in a deprecating way to the court.
Yeah, I understand.
But again, range 1 is significant, but this would just add another potential issue for appeal. If the AUSA would have unsealed everything, I would be sitting right there politely listening. But we don't have the appropriate records before us, and we would ask that it be range 1.
Thank you, Mr. Isaacs. General, anything else? No. Okay. This is something, usually when I have a sentencing, I rule upon the range along with everything else, and it's generally not in dispute. It is in dispute here, and there's a very big distinction depending upon which way the court rules. I think it is important for the parties to know my ruling on that issue before they argue the remaining things that we need to discuss today, the application enhancement, mitigation factors, and anything else along those lines. So I hate to take a recess to do this, but I think this is an important question. I do want to go back in chambers and look at this a little bit before I make my ruling. I appreciate everyone's patience. I know you've hung with us all day here today. But this is an important question that we need to resolve in the correct way. So I'll be briefly taking the issue under advisement.
Did he say he was gonna rule soon? Sorry, guys, me and Cody are trying to figure something out.
I wasn't listening. What'd you say?
No, I was asking everybody if he said he was gonna rule soon. Yeah, if you're watching this on TV, there's like a 5-minute gap. Sorry, guys. We were trying to figure out something about our cars. And I don't want to leave and just leave the computer running. I think it's agriculture court. I think it's just like their seal. Hey everyone, I'm still here. We're just trying to figure something out. Okay, figured it out. Sorry. What is this recess? Doesn't the judge have the final ruling in the sentencing? The DA can recommend what they want, but it's up to the judge to decide, you know, to make his judgment. The DA could ask for, like, 16 years, and the judge has his statute with that for whatever this is. It's like 12 to 20, so it might fall in that window somewhere. So the judge can pretty much go anywhere. Ay, ay, ay. Let me know when you want me to call the Uber. Take the Mustang back.
Take the Mustang back. It's up to you.
And then just park your car. Park your car on this side, and then when this is over, we'll go and get it. So this recess is for the judge looking up something in the back. What I'm confused about is why the drug charges. I don't know. That's what I'm confused about. Isn't he really sick? Yeah, that makes sense. I would just, because this isn't drug related, that's why I was like confused a little bit. Yeah, that make yeah. That's. I think he did 5 years for that. I'm pretty sure of it. Yep. Well, I'm looking at on the TV, and now they're just showing Kristen back on the stand again. So they're still in recess.
Yeah, that's a while for all of that. It seems like it's back at trial.
Oh man. Yikes. That's what I'm thinking. I thought like the minimum was 12. Hey, busy. Nope. Judge is back. I think. But now I think because they brought the ex-wife in to testify to get more time. And now whatever they're looking into on these past drug charges, more time. True, Paul. Hey, Gooch. Yeah, the ex-wife tested him when he was strong. But there's definitely still a recess because now the legal analysts are on the TV talking about it. I guess I could turn it up. Since I'll put the volume up on the TV so you can hear what they're saying.
Because at first those cases, they frightened me so much, Josh, because I mean, even
can you hear good?
Than defendants I had who would engage in gang violence and things. And you know why? Because it was more controlled. It was more controlled abuse. And it was behind closed doors. And the batterers would come to court and smiling and, you know, and they promised to do better and their temper, you know, just got out of control. No. It's not that they couldn't control their temper. They can absolutely control their temper. And I just kind of made it to my mission to talk to people who know a lot more than I do about domestic violence. And now I volunteer in the prevention movement and really think it's something that needs to be talked about because it's so uncomfortable, right? It's such an uncomfortable subject. It's hard to breach for that reason. Share with us some of, you know, your thoughts on that. When you go to court, Josh, and you see these types of cases happening and you see one side, you know, a batterer maybe puts on for the judge, for the court staff, or the prosecutor, but then, you know, when he or she goes home with their partner, it's going to be a whole nother story.
Yeah, and the complexity of domestic violence is why I'm really drawn to it because, like you, these are real stories and the victimization and the harm, it's immediate. You can't look away.
Oh, no
there
problem,
are pictures
Grace.
that you've seen, that I've seen, that everybody in the prosecution defense.
It only means that the Geno stuff gets pushed back more, but that's okay because I needed a break from it anyways.
Some of these images burned in, and you didn't even live it. Domestic violence is the big topic for societal control and criminal justice over the next 20 or 30 years, because unlike that gangster case, unlike that drug trafficking or something like that, these are crimes of intimacy, passion. It brings in mental health issues. It's everything that we struggle with as a community, because we also have to
Welcome
realize
back, Maureen.
that good people make terrible mistakes and do bad things.
Mm-hmm.
And there are people who are victims who are also abusers. It's one of the struggles, as you know, as a former prosecutor, why the state struggles prosecuting some of these cases is because there are mixed issues involved. If you are a victim, you might have also committed a crime. And since it's sloppy, that makes the defense attorney's job easier. And this is high.
I'm surprised to see Geoffrey
really
like handcuffed the whole time.
Trying to unpack these cases.
Yeah, they're really tough cases to understand. It's a different criminal dynamic than you see in many other cases. I want to play another clip now. This is from Allison Moon, Paschall's ex-wife. She details the first time she was abused by him, and it was 4 months into their marriage. Can you tell us about the first time that there was physical abuse? Yes, 4 months after we were married, we were having a conversation, and it was not long into our marriage. I began to question his fidelity and whether he was maintaining loyalty and being honest with me about things. And so when I brought it to his attention, he would often get defensive.
I don't know.
And start to make me think that what I was saying was wrong, or that I was crazy for thinking so. And the first time,
Oh my God, Mary should know better than that.
Just immediately snapped, like no warning. He jumped on me and held me to the ground, but had his hand over my mouth, just squeezing it, like, hey, stop talking, basically. And after that first time, he was extremely apologetic and promised it would never happen again, and wanted this marriage to work out. And I believed him. After that, though, there were many instances of increasingly more violent things that he did to me, such as strangling me, holding me on the ground and strangling me, and dragging me by my hair, backhanding me in the face. He's elbowed me in the back, and each time he would be threatening me and I didn't believe I could do anything about it. Yeah, it's not as easy as why doesn't a victim just leave? It's something that it's very hard to explain. And the best way I could put it is they love the batterer and just want the violence to stop. They love the person that they're with. They don't love what they're doing. And these batterers are manipulative, aren't they, Josh? And they convince them with the love bombing and the promises and all of that, oh, it was just an isolated incident. I'm going to do better. Just stay with me. I need you. They convince, the person they're victimizing that they're going to do it better. It'll never happen again. And it always does.
Yeah, people don't understand that the relationship is way more complex than, oh, she just needs him for money or he's lying. No, it goes all the way to the core of the entire dynamic. It's why people are sometimes even attracted to each other because of the call and response that's missing. And when people are raised in an environment where domestic violence or inter-partner violence is present, they expect that in future relationships. So it really is this tragic situation where victims are attracted to people with a predilection to abuse. Then the relationship is based off abuse.
Well, Ashley just texted me. She's in the courtroom with the blonde hair. And I asked her, I go, do you know how much longer it's going to be? And she said, not sure.
Cultural habits manifesting in a relationship with a violent and abusive result that's unhealthy for everyone.
She's the one that made us the cute little Care Bear thing out of wood. When we were at Geoffrey's. What? I'm live, yeah.
Problems never solve themselves. It's terrifying.
Yeah, and we have to just continue the conversation, keep talking about it as we are on the show. Unfortunately, we're out of time right now, but thank you, Josh Schiffer, for coming on the program, giving us legal analysis today.
Oh, it might be starting back up. Let's see.
Here on Court TV. My time is done here. The judge is in chambers deciding whether or not Geoffrey Paschel's prior felonies can help enhance his penalty on this domestic violence case. Ashley Wilcott will be here next. I'm Julie Grant. It's been great being with you.
Let's take care of each other. Do a little more good.
I had just commercials on right now, so I muted it. Oh, I'm tired. You want me to call it Uber?
Yeah, go ahead and just, because I don't know how long it's going to take to get here.
The plea deal was supposed to be like just no jail time, and I believe probation.
I think it was a year probation.
And then he, said no to it. And I think after that they added the kidnapping charges to it, and that's what really the bulk of the time is coming from. If there were no kidnapping charges, I think he would have served, and he went to trial. I think the max term would have been a year.
Like the kidnapping thing wasn't on like.
I don't think the kidnapping was originally on the books when they offered the original plea deal, but I could be wrong.
So then, why is it such a big deal now? Then,
well, because he got found guilty of it.
Well, no one. I know, but I don't want to say it on my.
Well, I gotta figure out this Uber. Stop distracting me.
What?
I said I have to figure out this Uber. Stop distracting me.
Oh, I know. I need to get the call here. I mean, it shouldn't go for more hours, right?
I don't know. Brooks said he was offered probation reckless with the DV on his record. And then Jeffries felt that, his exes were conspiring to put him in jail, and he was going to fight it. And here we are. Why isn't Uber downloading on my phone? Uh-oh. Did it end?
I don't think so.
Uh-oh. Hold on. Hold on. I think they stopped the feed. Let me put the...
When that starts again, we will take you there to hear the sentencing. Now let's shift gears to the trial that we've been covering live, and this is Travis Ranking.
Now this is a different.
All right,
case.
so they
back with the sentencing, she said.
I don't know what to do.
Just hold on for a while on this bit. Hang on.
And I also don't know why this isn't working. So right now they're showing other stuff on Court TV, and I think they cut the feed. So...
Well, they did say when it was available that they will be going back into coverage for the sentencing. So I don't know. We're on the Tennessee case right now.
I just don't know how long they're going to be on break for. They could come back in 5 minutes.
Well, she just said 10 minutes on this case, the Tennessee case. So I don't know what they're doing here.
Well, that's pretty much the same thing he told me. And I said, yeah, but if you're facing no jail time, maybe, you know, with your past, it might not look good. But he wanted to fight it. Uber goes, where to? 9940 Las Vegas Boulevard. That's the last time we used Uber. Okay, so let's see. How do I do this? Where to? I know. Dang, $18
for a one-way fucking ride, just barely even over.
It's 6 minutes. I'm gonna hit it.
Do you want to wait and see if they come back with?
No,
a
I'm just gonna wait here.
Go?
I don't know when. I don't know.
All right, just hit it. Like whatever. Well, I mean, we have to take action to like. I don't know your torture.
All right, so he's 6 minutes away.
All right, that's fine. I'm pretty much ready, so. Did you already pay and leave a thing on there too, John?
What?
Did you pay it and leave a tip on there also?
Yeah, yeah.
So.
You need a mask, by the way.
I think they're all in our fucking car.
We'll make a makeshift one. Okay. Okay, Oleg is on his way.
Okay. Thanks for sharing. You're not showing yourself a penny at this.
I think Kristen, right? Wouldn't Kristen have been the one? Because during the testimony, when she got to the neighbor's house, that's when the neighbors called, I believe, how it all went down, and they arrested Geoffrey then. Yeah, it was Kristen. You're talking about the Waffle House shooting now. I hope this gets settled today too, because I can't do this all day again tomorrow. I'm just making sure you have the card.
I have it. You get this?
Yeah.
This is an area that really needs to be developed by medical experts who examine him and examine the facts of so it's really something that, as a defendant, he can't add a lot to.
You have the card though, right?
Listen to a little bit of testimony about the person who examined him.
I don't think I need anything
So this defendant got
from.
some
I'm just gonna take your license with me just in case they ask and like be like, he can't speak to that thing, whatever.
And then park your car like on the side street there, and then take mine back.
Because I don't know the area over there either. I don't know.
It's just a side. There's a side street literally on the corner. Park in front of somebody's
Let me
house.
just keep it there because they're open till 8. So we'll see.
Suffered from schizophrenia. So that was based upon his
What else is going on today?
behavior while he was with us, also reviewing his records as well. So he had multiple symptoms of schizophrenia, more than what's required to meet the diagnosis. He had delusions. Actually true. He had hallucinations. He was hearing and seeing things that weren't real.
Wait, just now?
He also had some disorganized thoughts. So his thoughts were scattered or confused, not really focused.
Wait, so Mary and Vara, I can never say her name right, aren't friends? I thought they were like friends. I thought they were chummy.
Facial expression does not match what a person's talking about. He also had some unpredictable agitation, and he believed that he was getting special messages from random things in the environment. So things like TV shows that he was seeing,
What's he driving?
videos to watch online.
He's 1 minute away. He's in a, I don't know, what is this? A white Mazda CX-9. His name's Oleg. Oh, I could do that. What's her thing? Yeah, let's do that. What's her IG again? I don't follow her. Blumenlow or something like that, was it? Oh, I got it. Thanks, Barbie. Oh, hold on. Let me lower this. Okay, so this is what Mary just said. She looks good. That's him.
Hi. Hi. Thank you for tuning in. Hello. Hi. Hello. It's nice to see all of you. Hello. Thank you for being here. I appreciate all of it. Hi.
This is Mary at court after she just got kicked out.
So, I am going to say hello, first of all. Thank you. Thank you. Said I look fabulous. Oh my gosh, because it's all about me, right? I'm just kidding. This is super emotional. But yeah.
She got kicked out for blowing him a kiss. Stupid.
Anyway. So, as you all know, shut up, Morgan. As you all know, I'm going to address this one time and one time only. Yes, I got kicked out of the courtroom because I blew Geoffrey a kiss, and that's what happened. Then the bailiff came over and said that he didn't want anyone speaking to Geoffrey or any of that. So no one was to speak to him, or they kept making him turn around. He wasn't even allowed to look at us. So that's pretty much what happened. I didn't want anyone saying that it was because I dislike Varia, or Varia and I are not on good terms. It had nothing to do with Varia. It had everything to do with me trying to talk to Geoffrey. So just they're not playing. So that's all that happened. So you can keep the speculations to yourself.
And also, if anyone calls me the C word ever again, you know how to get in touch with me. Say it to my face. Okay, that's your one and only warning on that.
Well, now I want to call her a C.
Yeah, so that's why I got kicked out. But I gotta go because I kind of want to watch what's going on court TV. So thank you guys.
So someone called Mary a C. The Action Gates news team blowing on all cylinders. Oh my God. I will ask Ashley. Good idea. So I have smart people around me, Brooke. I just asked Ashley. I don't know if she'll get back to me. I'm gonna also ask her if she's not friends with and is she friends with Varia? Varia? For 3 years, I have not been able to say this woman's name the right way. But Mary and his second wife, whoever that was on the stand today, they look they could be sisters. Varia. Is that right? Vaura. Does anybody want to come up while we're waiting? I'll drop the link. While we're still trying to figure this out. It's Vaura. Hey, Dorit.
Hi, honey.
So what say you about all this going on today?
This is ridiculous. I hope he gets 20 years and they hang him. I can't stand him.
It's looking like it's going to be that way.
Yeah, he's a dirty old chap, that's for sure, and a perv. So, John, I didn't catch any COVID, and we were together.
Yeah, thank God. I don't know. It just, after we got back from Vegas, we just didn't feel good. And then it really hit like hard, like I want to say like January 2nd-ish. Maybe we didn't get it from Vegas and we got it from, somewhere else. It just seemed like after we got back from Vegas, it was just all downhill.
Well, Angela wasn't sick or her daughter or anybody, right? You're the only ones.
Yeah, I believe so.
Well, at least
we got it from somewhere else. I don't know. I just it smacked the crap out of us.
I know. My girlfriend ended up in the hospital for 4 days, and she didn't think she was going to make it. It was touch and go. She got it really bad. What is taking them so long?
I know it's. Oh wait. Oh wait. I think the judge is back up. I don't know if this is right now. 106. I think it's sorry. Let me drop you down, Drew. I think
okay, go ahead.
Hold on, I gotta get this back on YouTube.
Any other state, government, or country that, if committed in this state, would have constituted an offense cognizable by the laws of this state. In the event that a felony from a jurisdiction other than Tennessee is not a named felony in this state, the elements of the offense shall be used.
Okay, they didn't start it back on Court TV on YouTube yet.
Offense is given.
So this is what the
So
TV.
if you look at the two prior convictions from the federal district court for the Eastern District of Texas. For one, you just look at the named offenses that you have here. One is possession with intent to distribute cocaine and marijuana.
I keep refreshing Court TV's YouTube and it's not coming up.
Regardless of the weight, if you were just looking at the names of the offenses, the possession with intent to distribute cocaine would classify as a Class C felony in the state of Tennessee. Also, regardless of the weight, the attempted possession would qualify as at least a Class D felony. Of course, if the amount was half a gram or greater in either of those instances, that would bump it up one classification. But at the very least, just judging from the names of the offenses, we're talking about Class C and D felonies. Just to be sure, though.
Hold on, let me see if I can get this on. See if I can.
The elements
Hold on.
of the federal offense, just to make sure that those offenses, as defined by federal law at the time they were committed by Mr. Paschal, would qualify under Tennessee law under the rubric that I just mentioned. It was a little difficult and tedious because I
I'm gonna have to unplug my computer.
A copy of the federal code from the turn of the millennium. I do have access, however, to the current federal code. Rule 202 of the Rules of Evidence do require the court to take judicial notice of the laws of the United States government. And I am so taking notice of United States Code 21 U.S.C. Section 841, subsection A, which, as it relates to both of these convictions, is the subsection that Mr. Paschal was convicted under. The statute in its current form was last amended December 21st of 2018. That doesn't end the discussion.
This is the judge speaking.
Sure that the elements of that offense had not changed since the time that Mr. Paschal committed these two offenses. So I looked at the legislative history of Section 841, and really what took me quite a bit of time to do, and while there was such
I'd say the Max Brook.
I looked at every single legislative amendment to Section 841 going back to before the time that Mr. Paschal committed these two offenses. And in each of those instances, there were amendments to Section 841, but Congress never amended the base elements that are found in subsection A of 841. So I don't know that this is necessary, but just to make clear what I was referring to and the law that I was looking at in order to reach this conclusion, I would like to make copies of both the statute and the legislative history exhibits to this record, as I have taken judicial notice of them. I'd like to make the current version of Section 841 as exhibit number 7. And then here I have all of the amendments that have occurred in Congress to that section since prior to the time that Mr. Paschal committed these offenses.
Yes, Crystal.
Now, this is a thick stack of papers, so I don't want anyone to think that all of these related to Section 841. Many of these amendments were passed in the context of a huge omnibus bill. One of them was the reauthorization of the Patriot Act. One of them was the Adam Walsh Act. So there were multiple portions of the U.S. Code that were touched by these amendments, but I was able to identify the specific portions in each one where Section 841 was amended. And in each of those instances, there were certain amendments made to 841, either changing sentencing calculations, making minor changes to language, even adding new offenses under subsection A. The subsection A was never amended. So I am confident after reviewing all of these that the current version of Section 841A is in fact the version of the statute that Mr. Paschal was convicted of in the Eastern District of Texas years ago. So you look at the elements of 841A, it shall be unlawful for any person knowingly or intentionally, one, to manufacture, distribute, or dispense, or possess with the intent to manufacture, distribute, or dispense a controlled substance. And that is the federal analog to our Section 417, our felony drug offense.
They still don't have it playing on
So under
YouTube.
federal law, it's illegal to possess with the intent to manufacture, which it is in Tennessee as well, distribute or dispense, which I think would also, either of those terms would be synonymous with our term here in Tennessee, to deliver. Distribute or dispense also could fall under the category of a sale under Tennessee law. And because you're dealing with cocaine in either of these instances, I think that Section 841A is analogous to Tennessee law. The elements are the same, that if these offenses were committed in the state of Tennessee at the time that they were committed by Mr. Paschal, they would be classified at the very least as Class C or Class D felonies, potentially B and C felonies if the amount of the cocaine was 0.5 gram or greater. Under the progeny of Apprendi, it is appropriate for the court to consider certified copies of judgments.
Oh, it's live again. Okay, hold on.
This in order to establish range or to enhance sentence.
I'm going to share the screen. It's going to be a bit off because the TV is ahead of what's on YouTube.
Conviction such as this.
Hold on.
In order to establish range or to enhance sentences. And based upon that, I do find at this time that the state has proven beyond a reasonable doubt that Mr. Paschal has
three convictions that can be counted on different offense dates. Two, of course, being the number that he would need to reach range 2 on a Class B felony. And for that reason, I do believe that the state has shown beyond a reasonable doubt that Mr. Paschal is a range 2 multiple offender. As to the aggravated kidnapping offense, making his range of punishment being somewhere within the range of 12 to 20 years.
Yikes.
So with that, I would like to hear argument from the parties regarding the appropriate sentence within that range. General.
Thank you, Judge. I know the court has read the sentencing memorandums in this case, so I won't belabor it, but I did just want to touch on the enhancement factors that we noted in our memorandum. The state, in this case, at a very minimum, is asking for a mid-range sentence of 16 years. We do believe that is appropriate given the number of enhancement factors that are cited within the memorandum. The first of which being that he has a previous history of criminal convictions and behavior. Again, we heard about the criminal behavior from the witness stand here today. That is completely separate and apart from this incident. We heard about years of domestic violence towards Ms. Moon. We heard about multiple instances of prior violence against the victim in this case. And so we would ask the court to find that that enhancement factor does apply. He also does have a number of misdemeanor convictions, as noted in the precinct's investigation report, that I did not include in my sentencing memorandum. He has a theft conviction from 2014, a theft conviction from 2013. Believe within those certified judgments from Blount County, there's also maybe a simple possession of Schedule 6 as well. And so
I love the law, and I love the way this judge went through all of the details in his analysis. Bottom line, what he said was the federal convictions count in Tennessee as prior convictions. Now he's hearing arguments from both sides as to what sentence they recommend, 12 to 20 years. We're going to take a break. We'll go back to court when we come back.
I wonder what's going through Geoffrey's head right now. 20 years. If he gets 20 years, he's what, 44? I think he's a year older than me. 45. I'll be 43 next month. I think he's like a year or two older than me. So that's like getting out of jail at 65 years old. Oof. I guess the good news is that he can get out of jail and like go to get a senior coffee at McDonald's. Something to look forward to. I don't know why the state went with all this work they did today. You know, I would assume they would have going to go for the max, but just an extra 4 years. I don't know. It doesn't make any sense. This is wild. To think that he could have had no jail time. That would sit and eat at my brain every day I was in prison, thinking I'm here for 20 years. And because of my ego, that would eat me alive. Like, that would just eat me, sitting in jail every night for 12, 15, however many years it gets, thinking I don't have to be here at all. Well, we know that they're going to appeal it. And especially going to court knowing you have all these past convictions and the drug stuff, you know, it's not like you're coming into the court like as a Boy Scout, never being in trouble before, like, you know. Oh, here we go.
It is time for our daily calendar call. Let's get you current on all the biggest cases that we are following here on Court TV. In Chicago, the former police
Me neither.
officer
I'd say put whatever you want on my
who
record.
17-year-old Laquan
No jail, fine with
is
me.
scheduled to be released today. Jason Van Dyke was convicted of second-degree murder in 2019 and sentenced to nearly 7 years in prison. He has served only 3 years and 4 months. In Louisville, Kentucky, jury selection has been delayed in the trial of an ex-police officer involved in the raid that killed Breonna Taylor. Kentucky's governor has declared a state of emergency ahead of an incoming ice storm. The trial is scheduled to resume next week. And in Tennessee, the sentencing hearing for the 90-day fiancé trial is underway. Geoffrey Paschel will find out how long he will be in jail for the beating of his ex-girlfriend that happened in 2019. The defendant maintains his innocence. And that's where we want to start, the Paschal hearing, the sentencing hearing, compelling testimony from 2 victims this morning. Let's catch you up. The court came back, like, you know, said, I've looked at his several convictions. He stands to serve on these charges, this conviction against
everybody
the
thought there
ex-girlfriend
was
for
a
kidnapping and
mistrial,
assault,
including
4 different
every
charges,
legal
12
analyst,
to 20 years. He then said, State Defense, do you want to make an argument as to how many years you recommend or you think he should serve? We're starting with the state's argument. You haven't missed any of it. Let's take you back to court now.
Your Honor sat through the trial, heard the testimony of Ms. Wilson. Ms. Wilson testified at trial that she testified at trial and today that she blacked out and was blacked out for probably half the time that this almost 2-hour assault was going on. She stated that she was in and out of consciousness. When they finally get up into the bedroom and she lays down, she's fighting to remain conscious so that she can try and then get out once he lays down. She talked about being in extreme physical pain. I mean, the pictures support that. She literally had, her forehead stuck out 2 inches. She had scrapes on just about every single part of her body. And in this case in particular, Judge, while I do concede that aggravated kidnapping does have the requirement of bodily injury, I believe that the proof in this case actually established serious bodily injury. And when we look at the statutory definition for serious bodily injury, it is protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement. And I think in this case, the evidence was that all 3 of those things were present. Ms. Wilson testified. I mean, this was blacking out for an hour, in and out for, almost an hour probably. She testified that she was in extreme physical pain, which makes sense given the size of the injury on her forehead and on the rest of her body. She had obvious disfigurement. I mean, she walked around with that knot on her head and black and blue for almost a month, she said today. And so while we do concede that bodily injury is an element of aggravated kidnapping, I think it goes beyond that in this case. When we look at bodily injury, the definition is a scrape or a bruise or a cut, things like that. That's not what we have here. We had a woman who had a concussion who was literally unconscious for half the time that this assault was occurring. And so we would ask the court to find that the injuries were particularly great. And that kind of goes along with the next enhancement factor, that during the commission of the felony, the defendant intentionally inflicted serious bodily injury to the victim. Again, we do believe that this does apply because serious bodily injury is not an element of aggravated kidnapping. It's only bodily injury. And we do believe that the evidence supports that she did suffer serious bodily injury. So we would ask the court to apply those enhancement factors. Again, as to the length of the sentence, this is a sentence that has to be served at a 100% service rate. He may receive jail credits up to 15%. But given the history that we heard from that witness stand today, this is an individual who, for the last 15 years at least, has tormented the women in his life, has verbally assaulted them, has mentally abused them and controlled them, and has physically assaulted them. Ms. Wilson testified that she can't even walk her dogs down the street anymore, and she has good reason for that. These women, we make a lot to do in these cases about the fact that the women stay, but these women stay because of exactly why they said they did, because he controlled every aspect of their life, and he's done this for the better part of his life. We do believe that he is an extreme danger to society.
Wow.
He's a danger to, obviously, the women that he chooses to bring into his life. He has a very high lack of potential for rehabilitation. As we saw from the witness stand, he is still blaming this entire thing on her. And even after conviction, he's directing his family to take his kids to her house, giving them her address and saying, take my kids there, and ask her to testify, for me at sentencing, to say that I've learned a lesson. He's taken absolutely no responsibility for this. And I understand the state, again, we understand that because he did plead not guilty. But we do not believe that he was truthful when he testified at the trial, and the jury also apparently did not believe that these injuries were sustained from falling into a door. And so we do believe that he has a very strong lack of potential for rehabilitation. And so, again, Judge, at a minimum, the state would be asking for a mid-range sentence of 16 years as a range 2.
Mr. Isaac?
Can you guys hear okay?
We are going to take a break. You just heard the state argue a mid-range 16 years for this defendant, saying his high lack of potential for rehabilitation is one of those reasons. We'll go back to court when we come back.
Yikes. Can you guys hear me? Okay, good. Thank you. Sorry, didn't mean to keep asking. I know, Brooke. This is wild. Julie, did you just mod yourself? Can't wait to hear what his horrendous attorney has to say. Here we are in the great state of Tennessee, and lines have been crossed. Good people of this court, the echo might be from the sharing. Maybe if I turn my computer down, my volume. Let's see if that. Is that better?
Call or visit us online.
Day fiance, you may be familiar with Geoffrey Paschel, was convicted in October of 21. Right now, we're in the sentencing hearing. The court said 12 to 20 years are the sentencing guidelines. The state just argued we want mid-range. 16 years, Judge, is what we are asking him to serve. We're going to take you back in the court. You've not missed any of the arguments because now the defense has the opportunity to make argument to the court.
May it please the court. We are before the court in a sentencing that is taking place after a jury trial, wherein Mr. Paschal, at the beginning of this journey, entered a plea of not guilty. Mr. Paschal took the stand in his own defense and was able to articulate what he says happened on the night in question with his interaction with Ms. Wilson. So it's in that context.
I changed the mic. Is that better?
The court in a sentencing hearing with two different versions of far apart, two far-reaching versions of what transpired on that night. The jury, after hearing the proof and the evidence, decided that Mr. Paschal had committed those offenses under Tennessee law. So as I stand before you today, it's atypical in terms of when we say that our client is remorseful, although he is, whether we're doing certain things to accept responsibility, because this was a trial where there was two very different differences of opinion. And having cross-examined the victim in this this morning / this afternoon. We don't wish any of those women that have testified or Mr. Paschal any ill will or disrespect, but there are very specific legal criteria that the court has to make judgments and findings based on the enhancement factors the state has filed. And I think the court has heard not only the testimony at trial, but the testimony of those individuals this morning. So we are asking the court to focus on the law as it applies to Geoffrey Paschel, the person, and the trial. Having said that, we have attached
Okay, it's getting better. I keep playing with the sound.
of support for Mr. Paschal as it relates to the appropriate sentence the court can impose. There are 39 individuals that have spoken to the court via their letter, via their proffer regarding Geoffrey Paschal, the individual. They paint a far different picture from the testimony that the court has heard this morning. This is a cross-section or a cornucopia of people that have interacted with Geoffrey throughout his life in a variety of contexts. There are periodontal surgeons, there are teachers, there are family members, there are engineers, there are leaders in our community. There are people that have known him his entire life. And by and large, throughout those letters where people are attesting and offering their opinion regarding Mr. Paschal and his character, which is relevant under Tennessee law as it relates to his amenability for rehabilitation, whether it relates to specific and general deterrence. They paint a Geoffrey Paschal that is supportive, caring, and there. For example, Denise Compton, a registered nurse, indicated that she had known Geoffrey through the years and found him to be an honest, pleasant, kind, caring, loving person, as well as a very nurturing father. He's a man who loves nature and all of God's creatures. I have personal experience witnessing each of these qualities. And she lists a number of examples. She talks about him volunteering and helping with Vacation Bible School when he brought his sons. When his youngest son fell critically ill, Geoffrey stayed with him in the hospital day and night until the end. Our church family helped with the arrangements while totally devastated by...
None of this was evidence and was introduced in the sentencing. And so I don't believe it's appropriate for Mr. Isaacs to just get up here and kind of grandstand his client based on these letters. No character witnesses took the stand, and so I don't think it's appropriate.
We're offered one. There's not been an objection by the state.
It hasn't been offered until now.
Well, it's been filed.
We're already ruling their objection. There has been no testimony regarding any of the items that were appended to the sentencing memorandum filed by the defense. As we know, exhibits to a motion or a pleading are not evidence. They will be part of the technical record, but they are not evidence that can be considered by the court as part of the record. Now, having said that, they have been appended, they will be in the technical record, so I'll let you argue your case.
Thank you, Your Honor.
Yes.
Well, the defense got away with attaching exhibits talking about the good character of the defendant, and the court just said that will be part of the record, and I will consider that when we come back. We'll go back into court for more argument by the defense.
Look at this. Don't say it out loud.
It moved.
Sorry, y'all. Yeah, that's fine. Sorry, guys, we just got breaking news about something else. That's what. All sorts of breaking news in court today, which we will not be speaking about right now. And nobody put it in the comments either. Oh my God, I cannot sit in this chair anymore. They got to wrap this up. I'm sitting in like an old school wooden chair that has absolutely. Oh, I need like a desk chair. I never thought we'd be at this for almost 3 hours now. Oh, it's coming back. It's on the TV. I don't know why it's not playing. Wait, let me put my volume up so you guys could hear.
Did you say that, I think I might have misunderstood your ruling. Did you say that he couldn't argue those or that he could?
I'm saying that they are not part of the record.
Okay.
As to sentencing.
I agree with you, Diane. But I think he thought he was going to get off. I don't think Geoffrey in a million years ever thought that this was going to play out the way it did.
These people were not cross-examined by the state. It's just not in the evidence of sentencing. Well, we are offering them as it relates to all the applicable sentencing factors. We are making our proffer for the record for the court's consideration. Again, we think that they clearly are appropriate for sentencing, and those, if I can for the third time, finish with the letter from Ms. Compton talking about when Geoffrey's loss of one of his children, about his involvement with the church community and his support.
I don't know why this isn't playing on YouTube.
From, again, a cross-section of leaders in this community, people that have been touched by Geoffrey. Michael Johnson, a legislative assistant to the Florida House of Representatives, talks about him being a genuinely kind human and witness the acts that he carried himself with on a daily basis toward his family, their children, neighbors, his work ethic, his family values. The list goes on. And again, it's interesting to me that say has made this objection because we respectfully have not ever had that objection made by the Knox County Attorney General's office as it relates to letters, and we understand they're not being offered as substantive evidence, but evidence of general specific deterrence and inability to rehabilitation. But we would ask the court not only to take judicial knowledge, but to consider those as it relates to the appropriate sentence. In terms of the state's enhancing or aggravating factors, they have indicated that they are asking the court to enhance Mr. Paschal's sentence based on serious bodily injury. Serious bodily injury is defined by
I hope I
law
never have to
under
hear this guy's voice ever again.
as a cut, bruise, burn, disfigurement, physical pain, or temporary illness or impairment, or the function of a bodily member, organ, or mental faculty. It's interesting. Serious bodily injury is defined as substantial risk of death, protracted unconsciousness, extreme physical pain, and it goes on. A broken bone of a child that is not applicable to Geoffrey Paschal, but those are elements, and the state had conceded in their argument that are applicable.
Anybody ever look up this guy's track record?
Aggravated
Is he like a good
kidnapping.
attorney?
They are not applicable to the offense for which he was charged and convicted, aggravated kidnapping. We did not receive notice. I mean, the state had made the choice to bring these charges, present those to the Knox County Attorney General grand jury. The Knox County Attorney General's office chose the method and manner they were presented to the grand
Hey,
jury.
hibbity bibbity.
And if they were going to allege serious bodily injury, then it should have come out especially aggravated kidnapping.
Oh my God, this guy would never last here.
Mr. Paschal would have had the right, we would have had the ability to raise the issue of serious bodily injury before the jury that was impaneled. But now we are addressing it in sentencing. We would respectfully submit that to ask the court to consider an offense greater than the offense which Mr. Paschal was charged with in determining his sentence, violates his constitutional right of due process. And we would also cite the court to State versus Gogol. A defendant has a constitutional
I don't even think this guy knows what he's talking about right now.
U.S. Constitution.
He's like in Plessy versus Ferguson, you know,
9.
like with your court cases. It's already done.
While an indictment has to prove adequate notice of what he is charged with,
Well, in Roe v. Wade, you know,
it also precludes the state from going in after conviction and seeking to enhance.
This defense is arguing for a lesser sentence, and the defendant in this case, Geoffrey Paschel, is expected to address the court. You won't miss a thing. Be right back here on Court TV, your front row seat to justice.
I need to see when I had my laptop on my couch, it was a lot more comfortable. Babe, did you park the car on the side street?
Huh?
Did you park the car on the side street?
No, they said that it's fine. They said, you know, just leave it here in the lot because yours was where they needed to like.
So it's
move
fine
other
there for
cars.
now?
It's fine there for now, but they said, yeah, you already paid for it, so just, they said, whenever you get back to it, just pick it up at some point tonight. So it's fine.
So it doesn't matter if we get it when it's closed?
Yeah, no.
Okay.
There's no gates or anything like that. It's right outside, so it's all fun.
We were supposed to pick our cars up from the shop. Coach just had an Uber without me and grab one.
I have to say, right, it is like, and look, new brake fluid. So
yes, I said plus. Yes, I was a history teacher. I was thinking of like old timey, like, you know, case law that, like, you know, Brown versus the Board of Ed, like, you know, stuff like that. That you know, he's like, well, in this case, you know, we're all in it together. Happy to be here with all of you. I can't believe it's 4 o'clock. I'm hungry.
I'm starving.
I don't know if you have you guys heard my stomach like growling this whole time. I've been trying to silence it.
They haven't been able to pee because I have no.
I'll go to the store. We've been on since pretty much it started. I think we started today like maybe like a half hour into it. As soon as it went on Court TV, I started. Oh, that scared me.
Are they back? They're back on or no? Oh.
I should have told you to pick up some McDonald's on the way back. Damn it.
Well, maybe if you want to do that for dinner tonight, we can do that on the way back after we pick up.
I am hungry.
Sorry, baby. I have to.
No, I'm good. I'm good.
I just want to make.
I want to say this started about like a half hour before I went live. Because I didn't know if I was going to go live and do this.
The case thing? No, that was on before.
I didn't know if I was going to do it. I don't. And then a few people had asked me, and I said, all right. Never thinking it was going to be this long. I thought, like, you know, sentencing, you've already been convicted. I didn't think there was going to be witnesses called and, you know, all that stuff that we've seen. I know, Maureen. I was just throwing out like old cases because this attorney is such a grandstander who loves to hear like the voice, you know, his own voice. That's why I was just throwing out old cases because it seems like he's just so desperate to throw whatever he can out, what he can throw out there.
He denied Mr. Paschal the right to have that heard by a jury of his peers. I would also cite the court to State versus Scott.
There he goes again.
Specific facts that are to State versus Scott as it relates to the specific facts that are the predicate for the state's enhancement. We would submit mitigating factors to the court, which we have filed. Mr. Paschal, while in custody, has taken 30 classes as it relates to anger management and rehabilitation. I think that's relevant for the court to consider, even though we dispute very strongly the events that transpired on that evening that were the subject of this trial. Also, we would respectfully submit, again, that serious bodily injury is not appropriate under the offense for which he was convicted. The court, in determining the appropriate sentence, is confined to consider the evidence at trial, the pre-sentence report, principles of sentencing and argument as to sentencing alternatives, the nature and characteristics of the criminal conduct involved.
I mean, look at what OJ did, and in no time. I mean, he got jailed later, but to look at like OJ
himself, and any result of a validated risk assessment conducted by the Department of Corrections. We would respectfully say,
This case
and we
law.
appreciate the court's careful consideration as it relates to determining the appropriate sentencing range with the convictions out of the
That's true,
federal
Heather.
district court in the state of Texas, which we respectfully disagree.
But it's not like Geoffrey was broke.
With.
Jeffrey,
But Mr.
has a
Paschal
nice house,
at a range 2
land.
is
It's not like, you know,
a significant sentencing range under Tennessee law of 12 to 20 years.
certainly didn't have OJ's
If that
money, but
conviction was not used.
seems like he could
as an
afford better than this
enhancing
guy.
factor, he would be range 1.
That's why I was curious to see if anybody knew his record.
Again, we do not want to deprecate or minimize any of the allegations that this jury found in the trial beyond a reasonable doubt as it relates to Mr. Paschal's conviction. But as it relates to serious bodily injury, in other cases, the court observed the proof and knows the extent of the injuries that were there. There are, and this is very significant, we had 2 series of photographs.
I think he's getting the max.
One series was
the judge can't stand the attorney. The jury certainly couldn't stand Geoffrey.
Then a few days later,
and the ex-wife's testimony today was just
which showed hematomas that were more pronounced,
damning,
taken by Miss Wilson. The medical records were
and it doesn't matter if
not
Geoffrey
in
did
trial.
20 classes in prison since he's been there,
medical evidence
or you know, had his neighbors say nice things about him. It's not
and
gonna.
Again, the major
Fred Scott
enhancement factor relied upon by the state is serious bodily injury. So if you take a legalistic, if you take an appropriate view, pursuant to our sentencing schematic that the legislature has mandated, I would respectfully submit that there is no evidence that would rise to the level of serious bodily injury as it relates to prolonged unconsciousness. Because Ms. Wilson was able to testify in great detail as to what happened, in her opinion, that night when she took the stand. Without laboring or giving examples of what the injuries could have been.
Oh my God.
The injuries are defined and limited by the.
You know what I'm thinking of? The Seinfeld episode, like the last episode.
No, by the photographs that were introduced.
Sue Ellen Mischke, the candy bar heiress, was walking down the street with just a bra on. Jackie was
at the trial
representing
Kramer.
And they tried to make her put the bra on.
Tennessee law.
And the bra wouldn't fit.
Aggravated kidnapping.
I was going to talk over him because I can't take the sound of his voice.
They require a 100% service rate. We would ask the court, based on the proof at trial, to sentence Mr. Paschal at the bottom of range 2, which is 12 to 20 years, to a sentence of 12 years. I think it's significant to know if the federal conviction was not used to.
I think we're all zoned out. I think he's like an ambient.
Range 1, the maximum of that range would have been 12 years. But in relying on the
I feel like I'm watching Darcy and
factors,
Stacey.
Pursuant to TCA 4035 210C2,
there we go with the code.
We would respectfully ask that he receive a sentence of 12 years and that the court find that the state has not proven the enhancing factors and aggravating factors that they have set forth.
Thank you, Mr. Isaac.
Here we go.
Mr. Paschal, in every criminal case before a court imposes a sentence in the state of Tennessee, the defendant is given an opportunity to address the court. It's called allocution. This is your opportunity to address the court if you'd like to do so at this time.
We have just a moment?
Yes.
Oh boy. Hey, Ellie. Right? Like, you know. Record what, Julie? No, you don't have to record. Jeffrey's, I don't know. What's a post on IG or something like that? Maybe.
Your Honor, Mr. Paschal would like to briefly address.
He was just speaking to his client about the opportunity for allocution.
Here we go.
I'm a 44-year-old man. I have a lot of love left in me, a lot of hope. I have dreams still. I have a beautiful family. Beautiful friends. I'm a dad. Got children right there. I'm going to be a grandfather here in May. I'm an uncle, I'm a nephew, I'm a son, I'm a grandson. I respect Miss Wilson child. I respect Miss Moon. Miss Moon is the mother of my child. She's right, I haven't seen her in 5 years. I wish nothing but the best for them. Although there is a different circumstance of events that occurred, I still respect them. I wish nothing but the best for them. As far as punishment, punished and broken. There, I can rehab. Rehabilitation is a form of punishment, and I want to be better no matter what. I do have faults, but I want to do better. I want to be the best at what I can be. And my focus is on doing that, whether it be be in my family or just be a better person all the way around. As you hopefully read in those letters, people have a common theme in that I go out of my way to help people. I don't need anything, I don't want anything. It just gives me that internal satisfaction to help people.
Yeah, he still hasn't said he was sorry.
So I ask that you have mercy on me. You have mercy on my family, my kids, and show me leniency in the sentencing so I can be a productive member of society and be back in their lives. Thank you.
Thank you, sir. Court is called upon to impose a sentence here that is consistent with the purposes and principles of the Tennessee Sentencing Reform Act.
Here we go.
And there are mandatory considerations that I must look at when imposing this sentence, set forth 4035-210B. Of course, I've carefully considered the evidence from the sentencing hearing, which included the pre-sentencing report. I've listened carefully to the argument of counsel. Of course, I'm very familiar with the nature and characteristics of the criminal conduct of which Mr. Paschal has been convicted in this case. He is allocated, which I will consider, and I'm also considering the results of his validated risk and needs assessment as set forth in the PSI, indicating that he is a moderate risk with high needs in the mental health domain.
That's not good.
Geoffrey just said, I'm punished and broken to the judge. I can be rehabbed. I want to be better. That's my focus. You are not going to miss any of this judge's decision. That's up next when we come back.
Lordy, lordy, lordy. Whether Geoffrey believes he was guilty or not, he should have still apologized. But he's still sticking to his guns. Ugh. I don't think he's getting 12. Like, he just gets in his own way. I mean, none of this had to happen. And like his ego and pride, you know. Yeah, the commercials on this is like annoying. Court TV has more commercials than MTV. Well, maybe there's a way of apologizing without saying, you know, I mean, I don't know. I feel like there's some, okay, I understand that. I feel like there's something maybe more I could have said. I don't know. Because that didn't seem like. Well, no, it's not. You know, obviously, I've never seen that side of him. And I've talked to him for 4 years, and you're always pretty charming. And obviously, I feel horrendous for Kristen and, you know, his the ex-wife that was just on the stand today. And anybody else? Oh, we're back.
90-Day fiancé Geoffrey Paschel in his allocution to the court said, I respect Ms. Chapman and Ms. Moon, the two victims who testified earlier today in the sentencing hearing. Right now, we are listening to the court as he delivers the sentence. Let's go back.
As I said, Mr. Paschal, like every human being, has good aspects, and he has some aspects here that we have seen that have been exposed that are very dark and are really evil. I know that I ruled that the letters of support are not properly in the record. I stand by that ruling. But I'm not surprised that Mr. Paschal be able to convince friends, family, fellow citizens.
He's not buying it.
That he's a good guy, that he's an upstanding citizen. He's a handsome guy. He's charismatic. His job. He's also very image conscious.
He's saying he's an actor.
I'm not surprised at all that he projects an image outwardly to the world that he is this type of person. What we have seen here and what has been exposed in this trial is that what is going on behind closed doors
I agree with you, Grace.
is much different than the image that Mr. Paschal projects out to the rest of the world. As I've stated, this behavior towards these women is sick. It is sadistic.
Oh, yikes. 20
it
years.
Goes beyond a desire to inflict physical harm on these women. It speaks of a deep psychological issue, I think, that Mr. Paschal has a desire to inflict as much emotional damage to these women as possible. The fact that he traveled to the state of Florida, sneaking the back door of Miss Moon's parents' home uninvited, engaged in aggressive sexual behavior following that intrusion.
Oh, this is bad.
I think the record shows here that Mr. Paschal is manipulative, that he thinks, hey, just let me talk my way out of this. He thinks he can do that. I'm deeply concerned that he, after being found guilty while in custody, was attempting to have a third party go see Ms. Chapman again, unsolicited, at her home, in direct contravention of any order that this court has given him regarding contacting the victim in this case. And not only that, he was willing to use his children as a pawn in this illicit scheme to try to convince Ms. Chapman to come in here and speak on his behalf. That's disgusting, and he should be disgusted by that behavior. This court is. Mr. Paschal, sir, if you please stand.
Oh, God, here we go. Moment of truth.
Geoffrey and Paschal on docket 116806, the jury having found you guilty in count 1 of aggravated kidnapping and Class B felony. For the reasons stated, the court finds that the appropriate sentence in this case is 18 years to serve.
Whoa.
Your arranged 2 offender, this of course will be a 100% service rate. As to the misdemeanor counts in 2 and 3, the appropriate sentence in those will be 11 months, 29 days to serve. Those will run concurrently with the aggravated kidnapping in count 1. The pleas will be incorporated into the judgment, or pardon me, the jury's verdict will be incorporated into the judgment.
Wow.
And judgment will enter at this time. The cost, of course, will be assessed in this case, and judgment orders will follow. Can we go ahead and pick a motion for new trial date?
Wait, how would that be 9 years with good time? That's half the time, Heather. Don't you get like 10% shaved off your sentence for good time? Not half. Or a third? I don't think you get half off for good time. And what concurrently means to everybody, it means
Go a
that
little ways out.
all charges will be served at the
Past the
same
30
time. He's not going to have to do the one charge for
Could we set
kidnapping
it
and then
on
do the next charge after that, and then
March
the
the
next charge after
17th?
that. That's consecutive.
Judge, I do have a trial starting in here on Monday. It's an attempted first-degree murder that might go that Wednesday.
Unfortunately, I'll be in Union County on the day.
Okay. Can we go to March 24th?
That should be good, Judge.
18 years.
I'll be in federal trial. I could have done it the next day, the 18th, right on the court.
Yeah, we are closed that day. Is that good for you?
I never heard of halftime for good behavior.
Well, we're closed for some reason that day.
I anticipate my trial starts the last week of March, and federal court's in the last 3 weeks, so.
Okay. So that put us in mid-April, you think?
Yes, sir.
Okay. What do you think about April the 14th?
It's good for the state.
I think in Knox County, I'll make sure those get moved.
Okay. You sure? I mean, we can.
Yeah, no, it's fine.
Okay. All right. Okay, April 14th will be the day for the motion for new trial. Of course, the time period to file that is within 30 days beginning today. I want to thank both of you. This is a difficult case, I know, for both sides. And I think both counsel conducted themselves very well and worked hard on the case. And the court really does appreciate that. Thank you.
Thank you, Judge.
Court will be adjourned until 9 o'clock tomorrow.
Boil all that down, and this defendant, Geoffrey Paschel, has been sentenced to 18 years to serve 100% of that time on the 4 counts, including the aggravated kidnapping and the assault of his ex-girlfriend. We are going to break it all down when we come back here on Court TV Live.
Wow. I don't even know what to say. What he said about Geoffrey, that he pretty much called him a sociopath. Oh wait, before I get screwed again, hold on. So Court TV, and I have it on my TV still. Again, what is now? Blah, 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 blah. Sorry. I don't even know what to say. That, and he was telling his mom to go over to Kristen's house after the thing. I've been waiting to see what they say when it comes back on the TV. They ended the live stream on the Court TV, so I still have it on the TV in the background. That's playing commercials right now, of course. This is crazy. And to think like it could have been all avoided for him. Oh, here we go.
Harsh new reality. The reality star assault trial penalty phase. Live coverage today on Court TV.
Tonight, on closing arguments, we have the biggest moments from today's proceedings in the Waffle House shooting trial.
Well, yeah, I mean, but then, you know, people have said that if he did apologize and that would hurt the appeal. I don't know.
Geoffrey Paschel and docket 116806. The jury having found you guilty in count 1 of aggravated kidnapping of Class B felony. For the reasons stated, the court finds that the appropriate sentence in this case is 18 years to serve. You're a range 2 offender. This, of course, will be a 100% service rate. As to the misdemeanor counts in 2 and 3, the appropriate sentence in those will be 11 months, 29 days to serve. Those will run concurrently with the aggravated kidnapping in count 1. The pleas will be incorporated into the judgment, or pardon me, the jury's verdict will be incorporated into the judgment, and judgment will enter at this time. The cost, of course, will be assessed in this case, and judgment orders will follow. Can we go ahead and pick a motion for new trial date?
Yes.
And welcome back to Court TV Live. I'm Ashley Wilcott, honored to be with you. You just saw it moments ago, the judge in the case, the sentencing of Geoffrey Paschel, 90-day fiance, may sound familiar to you. He got 18 years, expected to serve 100% of that 18 years.
So no
Still
time
with
off.
us to talk
That
about
is,
this. Criminal defense
wow.
attorney, former prosecutor in Texas, Nicole DeBoard, and welcoming now in Los Angeles, California, attorney trial consultant, Dina Seigdahl. Thank you both for being with us. Dina, let me start with you. And what do you think of this sentence? 18 years to serve 100%.
I thought it was interesting that the judge in his sentencing remarked about the sadistic nature, how manipulative it was of him. And I think people who are familiar with domestic violence in general probably are kind of like that he said that, because of course he did the assault and the kidnapping. He was already convicted of that. But those other elements of kind of domestic abuse relationships, the manipulation,
Thank you, Kate.
the sadistic, kind of often doesn't come in as much in terms of what people see. And the fact that he used that and saying, no, he really needed to serve his full sentence, I think aligns with how people see how truly harmful that is in somebody.
And today's testimony from these two victims to me was just so compelling because as I was listening to their descriptions, it was textbook what we know about abusers in domestic violence circumstances. And I felt like it was so compelling. And I would agree with you, Dina, that this judge absolutely used language. He did say there was a dark, evil aspect to Geoffrey Paschel and that he was disgusted, quite frankly, at some of the behaviors. Nicole, juxtapose this with, if you remember, the state had offered a deal to this defendant where he would not have served any time. Now he got 18 years.
She just said that, see? Like crazy.
Boy, those are really tough cases for the lawyers who were involved. You can do everything you can to help a client understand real and significant risks in cases like this, but certainly you don't ever want to do any arm twisting when you have a client who's insisting that they are innocent of the crime so that they can have their day in court. But this is indeed what makes defense lawyers nervous. And, you know, just because you get some sort of a great low offer on the beginning end, especially in a domestic violence case where a complainant or a victim will have to testify and it could save them that appearance in court, do not confuse that with the idea that somehow the state or government believes that they have a weak case.
And Dina, do you think that he's still, like, I don't even need to phrase it the way I was going to. Here's what we know. His attorney said when he was making his argument to the court of a lesser sentence, he said there's two versions of this story. Yes, he's convicted, but he maintains his innocence, basically. And then when he had the opportunity and the defendant addressed the court, he never indicated any remorse or that he'd done anything wrong. He said he had respect, even though there were different circumstances of events, he still had respect for the two victims. And so I just wonder, does he still think he did nothing wrong?
I think so. And that's not uncommon, right? In a domestic situation, they often feel justified in what they did. I thought it was interesting. He also said, he alluded to the rehab he's had as already being punished. That doesn't really sound like somebody who feels like they believe they needed rehab. You wouldn't necessarily see that as a punishment. You would see that as an opportunity. And I think the judge got that he really
I'm sure they're going to appeal it, but this judge
to kind of own what he did.
Hates him.
So let's talk about some of the legalities, Nicole, because a lot of viewers talk about the fact when you have a conviction for more than one count, like Geoffrey Paschel did, why does a court decide to do a concurrent sentence? And we know that concurrent means they run at the same time. So he got 18 years on the greatest charge, the aggravated kidnapping, and then on 2 misdemeanors, 11 months, 29 days. But because it runs concurrently, he would only serve 18 years. What is the purpose or point of having sentences
for a court to run sentences out of the same conduct at the same time? If you don't have a series of separate events delineated by something completely different relationship, different timing, then it would be normal for the courts to run the sentences at the same time as the court has done here. I would still caution defendants and oftentimes have to have this discussion with my own clients. It is not necessary that the court in many instances run those sentences concurrently. The court in many cases has the ability to stack those sentences one on top of the other.
Right. Absolutely. I want to take an opportunity while I have you both with me and for the viewers. Let's listen again to Geoffrey Paschel and his emotional statement.
I'm a 44-year-old man. I have a lot of love left in me, a lot of hope. I have dreams still. I have a beautiful family. Beautiful friends. I'm a dad. That children right there. I'm gonna be a grandfather here in May. I'm an uncle, I'm a nephew, I'm a son, I'm a grandson. I respect Miss Wilson Chapman. I respect Miss Moon. Miss Moon is the mother of my child. She's right, I haven't seen him in 5 years. I wish nothing but the best for them. Although there is a different circumstance of events that occurred, I still respect them. I wish nothing but the best for them. As far as punishment, punished and broken. There, I can rehab. Rehabilitation is a form of punishment, and I want to be better no matter what. I do have faults, but I want to be better. I want to be the best at what I can be. And my focus is
It kind of reminded me of the end of Mrs. Doubtfire.
Be in my family or just be a better person.
And I know it's a weird comparison. Remember at the end of Mrs. Doubtfire when Robin Williams was like trying to get custody and the judge, the judge gave full custody to Sally Field because they said that Robin Williams was a talented actor and he was just acting
to help people
through it. It kind of reminded me of that. I know it's a weird comparison to me.
He had mercy on me.
Except in the movie, Robin Williams really did love his kids.
And show me leniency and sentencing so I can be a productive member of society and be back in their lives.
Dina, what's your reaction as you were watching Geoffrey speak to the court?
Oh my God, LRM, you never saw Mrs. Doubtfire?
Similar actually to what the judge's reaction was. He says he's charming. He does. He comes across charming. Those tears may have been real, may have not. But there wasn't a whole lot of remorse in there.
Yes,
he
it was.
really doesn't, it isn't accept responsibility. Again, he seems to
He didn't, like she said, he didn't expect responsibility.
So it did sound like just kind of a lot of talk. And I think that's
they
why
took
the
him
judge
back
wasn't
out of
really
the courtroom
swayed
and
by it.
it's done.
And the same question for you, Nicole, as you were watching him speak,
I'm so
what did you think?
A lot of people.
Oh, I have one small disagreement with Dina, but I actually think we agree, and that is to say I did hear remorse, but it was for himself. It was not at all for what he is convicted of doing. He was trying to almost tell the court that the judge shouldn't sentence him because his family needed him or that his
I don't know,
friends needed
JG.
him. And to me, I cannot imagine that fell on the judge's ear.
Maybe he's
as
some
any
grand
sort of
manipulator that
sympathetic plea for mercy. It's far better to have your lawyer arguing
charms
for
everybody.
mercy
I don't know.
and you arguing why you are safe to
All
be
I can say is that I have
sentenced to a
never,
lower sentence, in the community
thank
that
God,
you've learned
I've
your
never
lesson.
seen that side
And
of
it's
him.
that adage often used with children. It's not that they're upset at what they did. It's upset that they got caught at what they did. You do have to wonder if some of that exists. I will say this, just my final thoughts, and listening to the judge and what he had to say to the defendant before he said 18 years to serve 100%. There was nothing really positive that he said. He said,
Yeah,
I'm
Wicked,
sure
we hung
that these
out
people in
over the
community
summer,
are
actually.
right,
We were at his house
they
for
did
a few
believe him
days.
to be kind and pleasant,
When we were doing
but
our
the
road
court
trip, we
finds
went to
him
Angela's and we went to
manipulative and thinking
Tiffany's.
that he can talk his way out of things and convince people of things. So I think that the court saw through accepted what the prosecution said and saw through what the defendant was trying to convey to the court. Ladies, you're going to stay with me because we want to pivot. We're also covering that live trial in Tennessee against the Waffle House shooter, Travis Reinking. We're going to take a break. When we come back,
Oh, look, another break.
You're not going to want to miss because the state now.
So I think it's, I don't know what else what more is to say. Personally, from my end, I spoke to him since before he was on the show. It's like, so I think back in 2019, I started talking to him. I think when he knew he was going to be on the show, or like right before it started airing. And, I never saw any of that. But obviously I didn't date him either, wasn't married to him, didn't date him, wasn't in any type of intimate relationship with him. So we were just buddies. We had good laughs, and, I've also never, in my almost 43 years of living, have never had someone that I know go through something like this. And then to see another side of somebody like this, it just, Yeah, you know, and
it's
you
hard
see the
to-
pictures of, you know, what's her name, Kristen, and obviously it's horrendous. I wouldn't want anybody to ever go through that. And then you heard his ex-wife's testimony today,
We've
which is
never
also
seen it. And he
bad.
was such a sweet guy. Like
Yeah, we didn't see it.
He
We,
was
you know, but we
always
also weren't
such-
we weren't
he
dating
was
him.
the biggest sweetheart like ever.
Yeah.
Like anything you needed, he was right there. Like yes, I can help you with that, or like I'll give you advice to do this. Like he was such a great like person. So we didn't see that side. You know, we just know the one.
So I don't want
side
people to
we
think
know.
that I, you know, that I how's the right way to word this? That I don't feel bad or that, you know, I believe Kristen and the ex-wife, and you know, and yes, they needed, you know, they got their day in court and they got their justice. But I don't. It's hard when you have like, you know, it's just hard in general. So I don't know. And I don't even know how the appeal is going to go. Does the appeal go in front of the same judge? Because if it does,
I hope not.
I don't see any hope for him.
Can't he tell his attorney that he wants to like whatever it is for a new judge?
I'll put on camera.
I think you can like request for a new judge.
But I don't
have
know.
to have the
I
same
don't know
judge.
how it
I think
works.
you can file for a new judge.
I don't know.
Because that judge just don't seem like he really cares to hear anything from him, and that's not fair.
And it goes back to the point, like, you know, Grace made a good point, you know, earlier. You know, what if he did take the plea deal and then he got no jail time, and then maybe somebody else was going to be another potential victim of him, and you know, we save, you know, that person a similar nightmare that Kristen or whoever else might have went through.
Yeah,
So I mean, there's so many different layers to this. I don't know. It's hard to see someone that you were friends with go through that, you know.
We love Geoffrey, you know.
It doesn't mean that we don't care about
the other
victims
people
either.
too, you know. It's hard. It's definitely hard.
18 years. That's a lot. I mean, murderers don't even get that much time.
No, they don't. And then they get out on parole in like what, 5 years? But he can't even have that? Like that's
I don't know. It's a lot to wrap your head around. And you're seeing this, my reaction in real time. Like I'm watching it just like you guys are watching it, and listening to it, you know, just like you guys are. And we were even thinking about driving down there, but we just got our cars out of the shop just now. With both of our cars were in the shop. Couldn't even gone down there if we wanted to. I don't know. I'm happy that victims got their day in court. But someone who was a friend of mine, and I don't know. So I think his family. I don't know. I don't know what's going to happen. We'll have plenty of time for it. So I guess that's it. I don't know what more to say about it. want to thank everybody for 3.5 hours. There's 500 of you, like 600 of you here at one point. And it's it. It's done. Seeing the pictures of Kristen, not easy. And of course, we want whoever, we want that person punished. And hearing his ex-wife, and, I'm sure there are others. I don't know. I'm going to end this. I want to thank you guys. I got so much more stuff to do. I got to finish putting this Gino stuff together. I have to. We got Sister Wives that we didn't cover, and still didn't do the recap for 90 Day. It's been a busy, busy week. So I don't know if I'll be live again tonight. Maybe we'll do an after show later. This has been a lot going on this week. So I will see everybody later. Thank you for being here and keeping me company and watching us together. And yeah, I'll see you guys in a little bit. Bye.